Madam Clerk, please call the roll.
Representatives Baum. Camper. Cochran. Faison. Garrett. Hawk. Hazelwood. Hicks of Washington. Love. Moon. Shaw. Whitson. Williams. Chairman,
Here.
we have a quorum.
Thank you very much. I'd like to call the Finance, Ways and Means Subcommittee to order for March 27th, 2024. Members, are there any announcements or personal orders before we begin? Hearing none, seeing none. We have a total of, I'm sorry, Leader Camper. I about blew right through that. Leader
That's
Camper,
all right,
you're
Mr. Chairman. I
recognized.
was preoccupied myself. Thank you, Mr. Chairman. Mr. Chairman, members, you all know today marks a year from the Covenant shooting, and I see we have the Safer Voices out here for Tennessee. We'd like to make you all feel welcome. So if you all would join me in welcoming them. Appreciate you all still hanging in and coming and making your voices heard.
Thank you, Leader Camper. All right. Anyone else like to be recognized for personal order? Seeing none, we have a total of 56 bills on our calendar today. So we will begin with item number one. Item number one is going to be House Bill 2921 by Chairman Williams. You have a motion, a second. Sir, you're recognized on House Bill 2921.
Thank you, Chairman Hicks and members. What this bill would do, it would allow mental health and substance abuse treatment and mental health services for those on TennCare to be given the same reimbursement rate. For far too long, mental health services that were other than substance abuse treatment has been at a reimbursement rate that was significantly lower, therefore creating a desire for service for mental health substance abuse treatment greater than that of mental health treatment. What this bill would do would put those two reimbursement rates the same, providing greater services, allowing for reimbursement rates to be higher so that we could get more mental health counselors in the state. I appreciate the speaker bringing this bill, allowing me to carry it. With that description, I'm happy to answer any questions members might have.
Thank you, Chairman Williams. Members, you've heard the description. Any discussion? House Bill 2921. Leader Campbell.
Thank you, Mr. Chairman. Thank you, Representative Williams, for bringing this bill. You know, we have, which I think is a great thing, as a state, have really started to talk more about mental health, put more resources toward mental health, taking away the stigma around mental health. And so I'm hoping that with a bill like this, you know, having the reimbursement rates higher could help more people get treatment and shake this stigma around, you know, this very important organ, you know, in our bodies, our minds. So I really appreciate that. I do have one question. Would this rate be on par with private insurance, or could you explain what you mean by putting it on par?
Leader Williams.
Thank you. Yes, the reimbursement rates for TennCare are higher currently than those in mental health substance abuse treatment than they are for mental health services. And so this bill only increases those rates in the TennCare space. Last year, the speaker also brought a bill as it relates to doing that for private payers. The hope is those private insurers will see the leadership of this body and follow suit as it relates to the provision of that care for their patients or their ratepayers. But this bill would not mandate that for private insurance.
Okay.
Leader Camper.
All right. Thank you. I appreciate the bill. Thank you, Mr. Chairman.
All right. Thank you. Further discussion again on House Bill 2921. Hearing none and seeing none, there is a cost associated with House Bill 2921, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2921 goes behind the budget. Item number 2 on our calendar is going to be House Bill 2930 by Representative Garrett. You have a motion, a second? You have a motion, a second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman. This is legislation, and I appreciate our speaker letting me carry this important legislation. Last term, we appropriated $75 million for the AOC, the Administrative Office of the Courts, to implement a statewide system where all our clerks can actually speak to each other and we can gather data. We've got over 350 court systems, and currently they can't speak to each other in the sense that we need to do. So this is implementing that particular plan to centralize that case management system for our clerks across the state. So with that, Mr. Chairman, I'd be happy to take any questions. Otherwise, I know this is where this is going, but hopefully we'll look at this at a different time.
All right, Representative Garrett, thank you very much. Members, you've heard the description and discussion again on House Bill 2930. Leader Camper.
That's all right. Thank you. Thank you, Representative, for the bill. Would this also include the juvenile court system being a part of this entire system? Are they included in it?
Representative
Is it
Garrett.
just the clerk?
Yes, I believe they are. So the whole entire state will be on a unified system. So the data will be very important once this is implemented.
Leader Camper.
Thank you. I appreciate that. I
You're very
remember several years back when we did we had the Juvenile Justice Realignment Task Force and the Blue Ribbon, and none of the juvenile justice, none of the juvenile courts could talk with each other, and you had families being affected by that. And it was recommended by that task force to actually do this. So I'm glad that we are at a point where we are really making a decision to invest in that system. And I know last year we did, and I hope that we can find some funds this year to do the same. Thank you, Mr. Chairman.
Thank you. Representative Garrett, any follow-up?
No, we're good. Thank you.
All right, thank you. Further discussion again on House Bill 2930. Hearing none and seeing none, there's a cost associated with House Bill 2930, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2930 goes behind the budget. Members, that brings us to item number 3 on our calendar. Item number 3 is going to be House Bill 2541 by Speaker Pro Tem Marsh. You have a motion and a second. Sir, you're recognized for a brief description on House Bill 2541.
Thank you, Mr. Chairman. This bill would add another tool to local governments to use in land use planning. The new tool is a voluntary energy siting agreement. No municipality or county must use this tool. The terms and conditions of the agreement must include the duration of the agreement, the location, the land involved, description and design of the project, and any other items agreed to by the local government and developer. The terms and conditions of the agreement would have to be approved by the local governing body. Once approved, from the developer's perspective, the developer would have a vested right under the Tennessee's existing vested property rights law enacted in 2014. With that, I'll answer any questions.
All right. Thank you, Speaker Marsh. Members, you've heard the description. Any discussion again on House Bill 2541? Hearing none and seeing none, we're now voting on House Bill 2541, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 2541 moves to full finance.
Thank you, Mr. Chairman, committee.
All right, members, that brings us to item number 4, House Bill 1988 by Deputy Speaker Johnson. I've got a request here to roll this 1 week. So without objection, House Bill 1988 rolls 1 week. Brings us to item number 5 on our calendar. Item number 5 is going to be House Bill 1893 by Leader Lamberth. You have a motion and a second. And sir, it looks like you've got an amendment drafting code 017397. Is that correct?
Yes, sir, Mr. Chairman, that is correct.
All right, we have a motion and a second on the amendment. You have a motion and a second. I think the amendment makes the bill. So let's go ahead, if it's the will of the body, to go ahead and get that put on. So without objection, we're now voting on amendment drafting code 017397 onto House Bill 1893. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. You are recognized, sir.
Thank you, Mr. Chairman, members of the committee. The amendment doesn't totally make the bill. There is one section I want to talk about first before we get into the amendment. The amendment deals with subdivisions A1 and Section 3. The remaining portion of the bill does a $400 million tax cut for businesses in Tennessee. This is a huge policy win for every single Tennessean. We have been a phenomenal state for business for the last decade plus. Businesses are flocking here, jobs are flocking here, wages are up. And in large part, it's because you all and our colleagues have continued to keep our taxes low, our regulations light while needed, but manageable. And this is a $400 million tax cut for Tennessee businesses that will reinvest that in their employees. That's a big deal. The rest of this deals with specifically a refund that we are proposing for businesses that have paid the F&E tax. So going forward, we're going to cut the franchise portion of the franchise and excise tax, period. One of the few states that have it left. We're going to cut that and not do that anymore. Makes things simpler for business and, again, puts more money in the pockets of Tennesseans. In this particular amendment, it is very different from the bill that you've heard announced out there before. And I've worked with many members of this committee and our colleagues to come up with this, as well as folks in the business community. This requires that any funds that are distributed as a rebate on taxes that have been paid by Tennessee businesses, that if you get a rebate under this section, your name, the name of your business, and how much you got is going to be public. Now, there was an amendment in the other body that went much, much deeper into private tax documentation and private, business information. We're not doing that. We're just saying, look, there's 7 million Tennesseans out there that all pay taxes in. And if a business gets a rebate and files for that and feels like they're owed it, then the people of Tennessee are going to know business name and how much they got. On top of that, we're going to just allow for a refund eligibility window for tax periods that ended on or after March 31st, 2022. You're going to have to file a claim by February 3rd of 2025. So by February 3rd of next year, we're going to know exactly how many people have filed for a rebate. And on top of that, if for some reason somebody out there feels like there is a lawsuit they want to bring against the state of Tennessee, which I would argue would not be meritorious. I don't think there's anything wrong with our franchise and excise tax from a legal standpoint. There are other lawyers that may disagree with that. I feel like we have a policy issue that we're addressing here. But if for some reason somebody wants to file a lawsuit against the state of Tennessee, first, it's going to cost you a whole lot of money to do so because we're going to fight it every step of the way. But you're going to have to do it by February 3rd of 2025. So that way we know exactly who all out there, which businesses feel like somehow or another they'd like to bring that suit. My hope is that with this remedy, none will, because we are being overly, I think, gracious to these businesses to do a rebate and a tax cut going forward. There is a requirement that on anything that is filed for a rebate, the Attorney General's office would approve the process so that we keep them in the loop on this. That is relatively standard for issues of this nature. If someone gets a refund, if they get a refund on anything that they file for a refund for the last year, we're only going back 1 year in this. The original proposal was 3. We're going back 1. If a business files for that refund and gets it, then they forfeit any opportunity to sue the citizens of this state, because that is what a business is doing. Let's be crystal clear about that. They're not suing the state. They're suing the 7 million Tennesseans that make up this state. So if a business wants to do that and show us what type of individual or business that they are, then they're going to have to bring that suit by a certain date. It's going to be transparent, and that's the road they're choosing to go down. But if they take a refund, that door is not open to them. It's over with, and we all move forward together, holding hands as the good partners we have been between, again, Tennesseans and businesses thus far. If an entity has got an ECD credit, that is a credit that has been given to them, again, by the taxpayers of this state. If they file for a refund, those ECD tax credits would be backed out on top. So that would come out first before they would get any kind of a refund amount. And again, I've already mentioned that it's a look back for 1 year. And if you are under a current ECD agreement, or if you're just under a tax structure that you would prefer to stay under as of December 31st of 2023, then you can stay under that structure. For purposes of valuation, some businesses may choose to stay under that structure. It's a small tweak, but it's important. And then there's a severability clause so that if any of this gets challenged in court, which again, my hope it would not be, there is a severability clause for that. So, Mr. Chairman, I know that's a lengthier description of what the original bill may have been, but that's on the specific amendment on what it does and what the bill does now as amended. I stand ready for questions, sir.
All right, Leader Lambert, thank you very much. Members, you've heard the description of House Bill 1893. Any discussion? Chairman Whitson.
Thank you, Mr. Chairman. And Leader, thank you for bringing this amendment. I like the transparency part of this. The federal government on the PPP loan applications, they listed those. I think that was important for our public. And also, I think on this amendment, it will do the same thing. So thank you.
Leader Lambert.
No response.
Any comments?
Thank you, sir, for your support.
All right, thank you. Chair Lady Hazelwood.
Thank you, Mr. Chairman, and thanks to the leader and a lot of people who have worked very hard on this issue to bring us to a place where we can all be comfortable. One of the things I do want to make sure I understand correctly, this transparency piece, the listing of the name and the amount, that only applies to these refunds in this particular case. It's not precedent setting for anything going forward. It is only in this particular situation. Am I correct?
Leader Lambert.
Absolutely. That is just if someone files for a rebate. They don't have to file for a rebate. There may be several businesses out there that decide they just don't want to do that. It will cost money for them. I mean, from an accounting standpoint, legal standpoint, everything else, to file for a rebate. And some of them may just decide, you know what, we appreciate the tax cut going forward. We're not going to do it on that road. And so their name and amount of tax that's cut going forward will remain private just as it is now.
Chair Lady Hazelwood.
And just to, again, I guess, make sure that we're on the same page here. The this listing of name and amount would only apply to the refund on this particular issue. If, next year a business realizes that they had, filed something in error and were due a refund, they applied to the state for the refund, that would be under a different guideline, and that transparency issue would not apply. Am
Leader
I
Lambert.
correct?
Absolutely, Madam Chairman, that is correct.
Thank you.
Thank you. Chairman Williams.
Thank you, Leader Lambert. Appreciate your diligence on this subject matter. I know you and I have had many discussions about it. And I also want to thank this subcommittee because we have thoroughly communicated about what we believe to be the wishes of this body as it relates to how we will handle this enormous tax cut that we're providing to our Tennessee businesses across the state. I will say there's a lot about the amendment that I like. In addition to the original tax cut, I will say I appreciate your diligence to make sure that those commitments that we made in ECD as it relates to F&E tax credits, that those people will be able to preserve the way they currently do business now under this amendment, as well as for those of us who have voted in past years to invest the taxpayer dollars in incentive programs across the state, whereas some we've invested $1 billion over the last several years. What this would do would say those credits or those investments of the state would be applied to those credits first, which would allow the state's liability to be dramatically reduced if we did make those investments to make businesses better and to bring jobs here. I do appreciate Chair Lady Hazelwood and your work on the transparency component, because I think it's important for the taxpayers to know where their money's being spent, how it's being spent as it relates to the refunds. As you and I and both chairmen have discussed, we have cut F&E tax many times in the past to try to make Tennessee a better, more business-friendly state, and never have we ever allowed someone to go back and get a refund. So this is kind of a new thing for us, but that's how much we care about our businesses, and we look forward to making sure that they continue to be good partners with the state, these businesses, as it relates to their F&E taxes, by providing this revenue. So I appreciate your diligence and hard work and for bringing this amendment to change the original legislation. Thank you.
Leader Lambert.
Thank you, Mr. Chairman. And Chairman, thank you for your work on this as well. I will note, members, that if you'll look at the fiscal note, it has changed a bit from the original bill. And when I say that, I say that somewhat sarcastically a little bit, because it's $700 million less than the original fiscal note. That is a significant savings. Make no beans about it. I mean, that is $700 million that belong to the people of Tennessee that they have paid in taxes, that while the original rebates were at $1.5 billion, this is only at $800 million. So again, a significant savings to the people of Tennessee. And I think still, again, does everything that the chairman just said to be generous and good partners with our business partners in this state. In fact, and I would argue it's overly generous. I mean, because we're cutting a tax going forward and we're providing some rebate to what's already been paid in.
All righty. Leader Camper.
Thank you, Mr. Chairman. Thank you, Leader, for your explanation of the bill. I had concerns about some of the things that the chairman brought up with transparency. I appreciate you addressing that. I would like for people that just kind of don't understand, tax law, that's watching this, that's kind of concerned about, even the 800 million that you're talking about. Could you explain to the members or the people watching what this tax is? What is this franchise tax that we're talking about authorizing a rebate for? You mentioned earlier in your statements that you felt the current structure was sound, yet we are concerned that people might be filing a lawsuit, which we would defend. But could you explain in layman's term, if you don't mind, what this tax actually is, so people can get an understanding of what the rebate is about?
Leader Lambert.
So I will tell you, explanation in layman's terms is difficult on this one. So I will tell you, when you get a bunch of accountants and lawyers in a room, they can go on for a long time about this tax. So, but I'm going to give you kind of just the couple sentences on it.
Yes.
So this has been in place since 1935. And in essence, Tennessee's franchise tax applies to the greater of the business's net worth or the value of the property it uses within the state. So what we're really talking about here is the valuation of a company. Think income tax, but more what you're worth at the end of a year versus property tax, what you own, and then in a combination and a formula of that. So that's a vast oversimplification of this, but that's basically what we're talking about. And that's the process we've had in place for over 90 years now. And so it has not been challenged in Tennessee. There is no lawsuit that exists out there. We have had a conversation for several years as to whether or not we should keep that valuation that way or just go over to excise tax, where we're talking about more the true valuation of a company and then paying fair taxes back to the state to contribute to the society we all live in here. We're all paying our fair share. And so, but to really get to that fair share, we can use the excise option on that instead of having to do this franchise excise calculation, which we're one of the few states that still do that. And so again, from a policy standpoint, to me, it seems like a good idea to just move on from that.
Leader Camper.
Thank you for the explanation. Also, I remember that in the department's budget presentation, when they talked to us about this and explained it, that it was coming and to be prepared for what it may look like, there was this phrase that was used, this terminology, unconstitutional by failing the internal consistency test. So within your amendment under section 3, it talks about that. Could you explain to me what we're doing right there?
Leader Lamberth.
So again, I personally disagree with any characterization that our law would be unconstitutional. No court has ruled that in over 90 years in Tennessee. No challenge has been successful in that regard. If you ask 10 lawyers for an opinion on basically any issue, you're going to get 12 separate opinions. You're going to have a couple lawyers, exactly, at least, that disagree with themselves. So, you know, what we're attempting to do here is recognize that, look, we're out of step with the rest of the nation from a policy standpoint on franchise and excise. It's been rumored for years, and there have been firms and companies that have said, well, maybe we should file a lawsuit on this or something. Well, nobody has. But why get in a big fight with our business community? Why not, from a policy standpoint, just cut taxes like we've done in the past, resolve any potential legal issue that's out there? Because going forward, we'll no longer have a franchise tax. We'll make sure that there's not even a risk of any kind of lawsuit out there, because I don't think the people of Tennessee want to be fighting with the businesses that are good corporate citizens in Tennessee. Why have this big, long, drawn out fight where the only people that are really going to benefit are going to be the lawyers? I say that as a lawyer, okay? I mean, but it's of no benefit to anybody else. And so for me, this is a good policy conversation to simply say, look, there is no lawsuit that exists out there, but what's the right thing to do by our business community in Tennessee? And the right thing to do is do away with the franchise tax, give some rebate for that because they've been paying it for all this time. And then let's move forward together as partners on just the excise portion.
Leader Camper.
I get that. Thank you. I get that. But in this section, it says that, and I'm just curious as what this means. The taxpayer knowingly waives any claim, that portion, and by the taxpayer's right and suing. And it talks about this unconstitutional by failing the internal consistency test. Inconsistency test. I need some clarity on that.
Leader Lambert.
Trying to get to.
See, I answered a question you didn't ask. Sorry about
See,
that.
there you are.
So it was hopefully a good answer though. So no, so if somebody were to get a rebate,
Okay.
if they were to apply for a rebate, then they waive any potential lawsuit that they might have out there. And that limits any potential liability for the taxpayers of Tennessee. So we're doing something extraordinary. As the chairman said, we are giving a rebate on taxes that have already been paid in, saying, look, we're going to give you a year's back taxes back to you. But if we do that, you're going to have to sign a waiver saying, hey, we don't think we owe you anything, but guess what? From here forward, you definitely can't sue us. Now, if they don't file for a rebate and they want to go to court and try to sue us and fight it out for the next 5 or 10 years, like is what happened in some states, obviously a company can go down that road. But if they get a rebate, then we get some certainty that this issue is just done.
Leader Camper.
Okay, thank you, Mr. Chairman, and thank you for your patience. On your amendment, section 17, initially it was the enacting clause, but we've added several other new paragraphs there under 17. So in the first subsection there, at the end, it has that same waiving of the rights. Is that just a correlation to the initial part we just talked to? Is this something else we're addressing within this legislation?
Leader
It's
Lambert.
mentioned twice here. I'm just curious about that.
No, that just lays out the time periods on this.
Okay.
Leader
And
Camper.
and just, thank you. And it just reiterates the fact that once you do this, you're waiving
Mhm.
your rights here that you will not, what the heck? Thank you, Jesus. Okay, all right. And I think that's it, because it's mentioned 3 times. It's mentioned further down, but you're just trying to get it all in sync for each section that you're amending, that if you do this, then you're waiving your rights in each part of it. Is that correct?
Leader Lamberth.
Yes, because again, if you file for a rebate, I mean, that's $800 million that we're putting aside saying, look, we don't think we owe you any of that. But to be good partners in this and everything else, we're going to say we're going to cut this tax going forward and we're going to provide a rebate here. But if we're providing an extraordinary rebate of that nature, then it would be ridiculous, I think, for any company to accept a rebate from the people of Tennessee and then turn around and sue and say, no, that's not enough. I want more. And I actually think it'd be a pretty bad business move too, because I've mentioned lawyers several times in this conversation. Lawyers cost a lot of money because we're worth it. I like to think so. Nobody else thought so. Y'all don't laugh at that at all. You're looking at me bad, okay? So honestly, these lawyers, I mean, for these type of suits, the type of legal fees that would have to be paid out are astronomical. I mean, you're talking about buildings full of lawyers that handle suits like this. It is very pricey for someone to bring a suit of this nature. But if somebody were to try to do that after they've gotten a rebate, to me, that would be a horrible, horrible move. And it would be a real smack in the face to Tennessee taxpayers. So we just want to cut that off and say, look, if we're going to give you a rebate, then we're just done with this conversation. Let's all move forward together.
Leader Campbell.
Last question, Mr. Chairman. Thank you so much. Leader, I know a lot of this is based on estimates, and we try to do our due diligence with fiscal review to tell us what we think the estimate may be. But is there any language that deals with potential under appropriations for the refunds? Let's say
Leader.
we get more requests than we anticipated, and we need another $400 million.
Leader Lamberth.
So we go through that process pretty regularly in the off season. The chairman handles that with the chairman of the Senate. There are expansion requests that come in. There are, either unspent revenues that are out there, reversions that come in. I mean, there's ways to kind of, balance that out. 800 million, and I trust our fiscal review folks. They've done a phenomenal job over the last several years. And quite frankly, their numbers have been right on the money on just about everything they've estimated. So I trust these numbers, but we're also not reallocating any of the 1.5 billion that was originally put towards this. That will be discussion that this committee and others would have as part of the budget discussion. There will be funds there if for some reason it will be over. I actually think it may be under this. And if it comes in under this amendment, make sure that any unspent money that was allocated toward this bill goes back to the general fund, which I think is important.
Leader Camper.
Thank you, Mr. Chairman. Thank you, Leader.
Thank you, Leader.
Chairman Baum.
Thank you, Chairman Hicks. If I understand you correctly, your amendment would completely eliminate the franchise portion of the E&F tax. Seems like some earlier discussion or maybe earlier versions of the bill had talked about only eliminating one of the two ways in which the franchise version of the tax was calculated. Maybe that's going back quite a ways.
Leader Lamberth.
I think it is because in essence, we're doing away with, I think it's the Schedule G filers, I believe is what, if I remember correctly from the statutory scheme.
Okay. I was thinking that maybe an early proposal had been to eliminate one of the two ways that the franchise tax was calculated, the version where it's calculated based on your property value, but keeping the net worth version of the calculation.
Leader Lamberth.
And when I say franchise tax, what I mean by that is the property measure of it. So I mean, franchise and excise, yes, still exist, but and so I know as a doctorate level economist, you're going to get further in the weeds than I will. But it is, yes, franchise and excise exist, but we're getting away with the property aspect of that, which is when I describe this, I kind of say franchise is property, excise is income. It's more complicated than that, but we are getting away with the property aspect of it.
Okay.
Chairman Baum.
I think I understand what you're saying now. So we will still technically have a franchise tax. It'll just be based on net worth. It will no longer be based on property.
Yes.
Okay, thank you.
All right, further discussion. Again, we're on House Bill 1893. Hearing none and seeing none, we're now voting on House Bill 1893, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 1893 moves on to full finance.
Thank you, Mr. Chairman, members of the committee.
Thank you. Members, Leader Lambert, while we have you there, we're going to go ahead and move to the addendum calendar. And Leader Lambert has these two bills on the addendum calendar. So item number one is going to be House Bill 1640 by Leader Lambert. That was previously considered and placed behind the budget. Funding for this bill has now been secured and it can now move on to full finance. So any objection to reconsidering our actions on House Bill 1640? Seeing none, we're back on the bill before us. We're back on House Bill 1640, item number one. Do we have a motion second? We have a motion a second. And Leader, let me get caught up here just a second. We're on item number one of the addendum. Okay, all right. Leader, it looks like there's an amendment that has been filed and we need to put onto this bill. It's going to be drafting code 015789. We have a motion and second on the amendment. We have a motion and second. Do you want to go ahead and describe the amendment, sir?
Yes, sir. Just takes out the word immediate and adds in imminent. Just makes it match with other statutes that are out there.
Okay, thank you very much. Members, you've heard the description of the amendment. Any discussion? Hearing none and seeing none, we're now voting on drafting code 015789 onto House Bill 1640. All those in favor signify by saying aye. All those opposed, no. The ayes have it. We're back on the bill as amended. Sir, you're recognized on House Bill 1640.
Mr. Chairman, we stand here 1 year removed from when 6 of our citizens were killed by an insane individual that stepped into a school bent on evil. Leader Camper mentioned in remembrance of those families today. I hope we all pray for them. But what those families have communicated to me and what Jillian Ludwig's family has communicated to both me and Chairman Williams is that, yes, they relish our prayers. Yes, they want us to think about them today, but they do expect action. I don't think there's one bill that's, well, hey, we passed that one bill and it immediately will resolve some of the issues that we have where we have insane individuals out there that are doing evil acts and harming and killing members of our state. But this bill absolutely will save lives and make a difference. It is named after Jillian Ludwig with the permission of her parents. She was a Belmont student. Her parents, when they testified that they chose Nashville and they chose Belmont because it's a safe place. I believe that. I do. But it's not safe enough. There are little girls in the grave right now because a person who was incompetent to assist in his own defense was charged with felonies in a court a couple hundred yards from right here. And everybody in that courtroom knew that that individual was dangerous. Everybody. And they just watched him walk out the door because our laws are not strong enough to say that that person who everybody knows is insane and is dangerous do not have a provision that this law will provide for where you do not walk out the door, period. That person either should stay in jail or should be immediately committed to an institution where they are kept at until they are safe. I commend Governor Lee and his team for providing the funding for this because a bill without funding would simply be empty words on a paper to these families that expect action. This bill has the millions of dollars of funding available for those beds where these individuals will be housed until which time they are safe. The other thing this bill does is it says that if you are housed inpatient, when you leave, you don't just walk out the door, not even from there. It is mandatory outpatient treatment. I got a call a couple of months ago on a case that I had prosecuted 15 years ago, and that lady had just passed away. We had gone through the laborious process that this bill fixes to actually get that person committed. It took the better part of a year. This will be almost immediate after doctors have testified, after lawyers have been involved, after a judge has evaluated. It's got all the due process in there. But that lady passed away and they called me because she had been under mandatory outpatient treatment the entire time. That's what we need to be doing. If someone is so insane or developmentally disabled that they cannot assist in the defense and they're charged with an A misdemeanor or above, then they will be immediately committed and have mandatory outpatient treatment. Jillian's family, All of our families in Tennessee deserve more bills like this. And yes, this bill will say that once you are involuntarily committed in that nature, you cannot have, possess, or purchase a firearm. If you're not competent to assist in your defense, you certainly do not need to have a deadly weapon in your hands. Mr. Chairman, with that, I stand ready for questions.
All right. Thank you, Leader Lambert. Thank you very much for this description. Members, any discussion? Again, we're on House Bill 1640. Chairman Williams.
Well, I thought I was going to hold it together. Leader Lambert, thank you for this bill. Had an opportunity to talk to Matt and Jessica Ludwig on Monday or on Tuesday afternoon after the governor came out with his AA. Obviously, it's very painful. As someone who has a daughter at Belmont who dropped their daughter off at the same time Matt and Jessica dropped their daughter Jillian off. 6 weeks later, they were going to empty her dorm room, same dorm room, all because the current statute didn't allow for us to handle these types of individuals in the way that this bill would ensure. And so it was our hope, and I want to take an opportunity also thank Governor Lee for hearing the Ludwig's voices, and he met with them, as well as this committee. I know Leader Lambert, you and Chairman Hicks and Chairman Hazelwood have advocated on behalf of this family, while they advocate on behalf of all the other families whose will not have to experience what the Ludwig family had to experience after this bill passes. And so they send their thanks. It's kind of a somber moment, but I do know one of the goals or hopes that they had as it relates to naming this law after their daughter is that the brilliance and talented legacy that she had before her would someday be remembered, and that her life would not be in vain. And so I'm honored to sign on to this bill as a co-prime sponsor. I appreciate the leader and his diligence to work. I will say I appreciate the general for bringing charges against the individual since we started moving this bill, and hope that this family would get a remedy. The challenge is that remedy will never be sufficient for any family. And so I just wanted to thank this body for their hard work, the governor. I want to thank the Ludwigs, Belmont University as well, because they were very supportive of them when they came to visit as well. And so I appreciate the diligence and the work there. And it is our hope that Jillian's name will forever be remembered in her legacy because of this bill and the actions of this body. Thank you.
Thank you, Chairman Williams. Leader Lambert.
Mr. Chairman, thank you. And Chairman Williams, thank you. This bill doesn't happen without your efforts, period. And I want to say that publicly. You have poured your heart and soul into this. But y'all, it's a year after covenant. I mean, I hope it's one of a whole bunch of bills that get passed in this chamber, that one step at a time, we make sure that there are no more covenants. There are no more Jillian Ludwigs that lose their lives. There are no other families that have to go through this type of hell. It's one bill, but it's, I hope, one of many. So I'd ask for your support.
Thank you, Leader. Chairman Moon.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this. Doesn't current law provide if a person's adjudicated mentally defective or is put into treatment, that they are flagged and they can't purchase a firearm in the background check?
Leader Lambert.
So yes and no. So we expand somewhat here. Many of the individuals that are coming through the court system that are not competent to assist in defense suffer from both dual diagnosis on mental health issues and had developmental disabilities. So they have diminished to the point where they are not able to assist in defense. It is very difficult to, in the current process that we have with this changes, to go through the separate process of having them civilly committed. It is a process that, quite frankly, most district attorneys' offices do not have the resources, the manpower, or the expertise in many times to be able to go through that process. It is largely a civil process. I have gone through that, but most of your district attorneys, quite frankly, handle almost exclusively criminal matters. They're very good at that. But when you look at this other process, which we are truncating down into one process here, it is just simply one that in the system it doesn't happen very often. And the next bill that I have is a partner to this one, because This handles what happens when somebody is in the court system and they have gone all the way up to the point where they're incompetent. The next bill deals with how do we get well ahead of that and identify that earlier so that someone doesn't degrade to that level where they're no longer competent. So yes, there is a process. No, it is not normally utilized. And we expanded a bit through this, but we still keep all the due processes in place where it is doctors that are testifying, multiple doctors, it is lawyers that represent these folks that are fighting on both sides of this, and it's a judge eventually that's making a decision in open court.
Chairman Moon, thank you. Leader Camper.
Thank you, Mr. Chairman. Thank you for the bill. Again, I'm just appreciative of the fact that we've decided mental illness is something we care about in this state, and we're willing to fund it, to make sure people are getting the resources they need, to live and to survive in this country. So I appreciate it. I'm supporting it. Thank the governor for funding it in his, there's my group coming in. Thank you, Representative. Appreciate it, Leader.
Thank you, Leader.
No, I'm saying, Leader, thank you for that, but it is y'all that will decide whether or not to fund this. So in a few minutes, you'll be voting on this, and I appreciate the governor putting in his proposed administration amendment. But as y'all know better than anybody, I mean, it's the legislature's budget, and so it's y'all's decision whether or not to do this. And so I would hope that we would choose that today, but thank you for your consideration on it.
Thank you, Representative Shaw.
Thank you, Mr. Chairman. I too want to thank you, Leader, for bringing this bill. You're probably the perfect person to bring it because you understand the system probably better than most of us on this committee. Certainly, I claim being a doctor, but not a lawyer. But I do thank you for bringing this, and I think you're probably solving more problems than even you've thought of, because this is very critical time that we're in. And I appreciate that and honored to get to vote for this kind of legislation. Thank you so much.
Thank you, Representative Shaw. Leader Lambert.
Only that if you will look at the fiscal note, I mean, it indicates that there are literally hundreds of individuals that will be helped by this bill. So to both y'all's point, thank you. This is one of those where you can point at and say, yes, these several hundred people will be benefited.
All right. Thank you, Leader Lambert. Further discussion. Again, members, we're on House Bill 1640. Hearing none and seeing none, we're now voting on House Bill 1640, moving on to full finance. All those in favor signify by saying aye. Aye. All those opposed, no. The ayes do have it. House Bill 1640 moves to full finance.
Chairman, thank you. Members of the committee, thank you. And Jillian's family, thanks y'all for sure.
All right. Members, we're going to be moving to item number 2 on the addendum, but first I'm going to go to Chairman Williams.
Thank you, Chairman Hicks. I recognize that I'm out of order, but I did notice in the room here on the third row on the left is the chairman of the Putnam County Commission, Ben Rogers, District 8 County Commissioner. Ben, will you please stand and make him welcome? So thank you.
All right.
Thank you, Ben, for coming. He chairs the county commission there, does a great job on the budget team, and so I appreciate all the work he and his county commissioners do. Thank you.
All right. Thank you, Chairman Williams. Leader Camper.
Thank you, Mr. Chairman. Mr. Chairman and members, I know I'm out of order, but I'd like to recognize my constituents who are here from District 87. They on the Hill, if you all would stand, and everybody make them feel welcome. Thank y'all. Thank y'all for being here.
Thank
you,
all
Mr.
of our
Chairman.
guests for being here. Thank you, Leader Camper. All right, members, we are again on item number 2 of the addendum calendar, House Bill 1643 by Leader Lambert. This bill was previously considered and placed behind the budget. Funding for this bill has now been secured, and therefore it can move out of finance. So without any objection, is there any objection to reconsidering our actions on House Bill 1643? Seeing none, we are back on House Bill 1643 as it is presented. All right, we are on again item number 2, House Bill 1643. You have a motion to second. Sir, you're recognized for a description.
Thank you, Mr. Chairman. I'll be very brief on this one. The state made a horrible error, I think, 15 plus years ago. We stopped paying for mental health evaluations for those charged with misdemeanors. We had a lengthy conversation about Julian's Law just a moment ago, but y'all, we got to do more to get ahead of it. Okay, so if somebody is charged with a misdemeanor and they're in court and their lawyer says, look, I can barely talk to my client. It just seems like there's some severe mental health issues going on. We should be paying for that mental health evaluation. It's the state of Tennessee versus that person. Right now, we just pay for folks that are charged with felonies. If we can start at the misdemeanor level and we can identify what those mental health issues are, then that person is less dangerous. That person gets the help they need. And so that's what this bill does. I do want to publicly thank General Glenn Funk, who has been asking for years in Nashville for just a pilot program to do this. Well, that would have helped a few hundred people in Nashville. This will be statewide, and we'll be able to help lots more than that. With that, Mr. Chairman, I stand ready for questions.
All right. Thank you. Again, we're on House Bill 1643. Thank you for the description. Any discussion? Hearing none and seeing none. We're now voting on House Bill 1643, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 1643 moves on to full finance.
Thank you, Mr. Chairman, members of the committee. Thank you for your patience, and for the other members that you have on your calendar, thank you for their patience too.
All right. Thank you, Leader. Members, we're going to go back to item number 6. But before we do, we're going to recognize Chairman Faison. Sir, you're recognized.
Thank you, Mr. Chair, members and committee people here. I just wanted you to see that we have the youngest new member of Budget Sub. This is my son, Tucker, and he's hanging with me for a little bit today.
All right. Welcome, Tucker. All right, members, we're back on item number 6. Item number 6 of our calendar is House Bill 1074 by Chairman Subcommittee. You have a motion, a second. Sir, you're recognized for a description.
I assume the amendment's traveling with the bill, Mr. Chairman?
Yes, sir. That's
Thank you very
correct.
much. Members, whereas medical doctors are allowed to continue billing for their services using a fee-for-service CPT code, these insurance companies pay chiropractors for their services using a global per diem amount. No matter how many services are provided to the patient during a visit, the insurance company pays the chiropractor a flat amount for all the services provided to that patient on that day. What House Bill 1074 addresses is this inequity by providing that same method of calculating payment for services must be used by insurance companies for chiropractors and medical doctors. That's what the bill does, just bring parity to the field.
All right. Thank you, Chairman Subcommittee. Members, you've heard the description. Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 1074, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 1074 goes behind the budget.
Thank you,
Chairman. All right, members, item number 7 on our calendar is going to be House Bill 2211 by Chairman Haston. You have a motion and a second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman. I've had 2 hospitals close in my district, 2 rural hospitals. This bill goes a long way to helping protect 14 other rural hospitals from having that same fate. And I'll be as brief as possible. The reimbursement rates for rural hospitals have been stagnant since 2006. This lack of adjustment has left rural hospitals dealing with rates that do not reflect the inflation rates of the past 17 years. A lot of times to the tune of 50 to 70% of a loss per TennCare patient in our rural hospitals. This bill aligns outdated TennCare reimbursement rates with the official break-even rates recognized by the U.S. Department of Health and Human Services for inpatient services for rural hospitals. And I know what the fate of this bill is today currently, but I did want to point out this because I think this is maybe the most important part of this bill. According to the National Bureau of Economic Research study on rural hospitals, for every job created at a rural hospital or every job at a rural hospital, it creates 16 jobs locally. All right, so if you play that out and we say 14 hospitals, say 30 employees at each hospital, 420 jobs at 16 jobs per local job, that's about 6,700 jobs there. And, for that investment of $215,000 annually from the state, not only are you probably protecting 14 hospitals from maybe future closures, you're protecting close to 7,000 jobs that may not just leave that rural area, but may leave the state entirely. With that, I'll be glad to answer any questions.
All right, members, you've heard the description of House Bill 2211. Any discussion? And I'll say, as a rural legislator that has 2 rural hospitals, I want to thank you for bringing this legislation, Chairman. All right, any discussion? Leader Camper.
Thank you. Representative Haston, do you feel like this lower reimbursement rate over the several years has led to the closure, or have kind of added to the fact that we've closed so many?
Chairman Haston.
I would say so, and I'm leaning more on the expertise of some of these studies and some of what the feedback I've gotten from the hospitals that have closed in my area, but I would say yes, absolutely.
Leader Camper.
Thank you. Appreciate it.
Thank you. Chairman Moon, did you want to be recognized? I didn't see it. Okay. All righty. Okay, we're on House Bill 2211. Further discussion. Hearing none and seeing none, we do, Mr. Sponsor, I do appreciate you bringing this legislation. Of course, as you kind of alluded to, it does have a cost associated with it, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2211 goes behind the budget. All right, Chairman Hayes, that brings us to item number 8, which is House Bill 2212. You have a motion and a second. Looks like you have an amendment that rewrites the bill. That's drafting code 017222. Is that correct?
That is correct.
Okay, we have a motion and a second on the amendment. Since it does rewrite the bill, we'll go ahead and get it on without objection. Seeing none, we're back on the bill as amended. You recognize.
Thank you. This bill's intent is to help improve reopening opportunities for failed or abandoned rural hospitals and hopefully prevent them from closing in the first place. It does this by authorizing the comptroller to put in protective measures along with the ability to transfer operations of ownership of a government-owned rural hospital to a healthcare operator. With that, I'll be glad to answer any questions.
All right, thank you, Chairman Haston. Any discussion? Again, we're on House Bill 2212. Leader Camper.
Mr. Chairman, I should have had an amendment to expand Medicaid. That probably would have helped the situation. Thank you, Mr. Chairman.
Chairman Haston.
I will say this, that more goes along with the previous bill, but that expansion would have cost $1.4 billion. My bill was $215,000. It's a little bit better, approach.
Yeah, I like
maybe,
those
but I
numbers
appreciate
much
the
better.
comment.
All right, again, we're on House Bill 2212. Further discussion. Hearing none and seeing none, as it has already been alluded to, there is a cost associated with House Bill 2212, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2212 goes behind the budget. All right, Mr. Chairman Haston, we are on item number 9 now, House Bill 849, again by Chairman Haston. Do we have a motion and a second? Have a motion and a second. Looks like there is an amendment that rewrites, so let's go ahead and take care of the amendment drafting code 010548. Is that what you have, sir?
Yes, thank you.
You have a motion and a second. Any discussion on the amendment? Hearing none and seeing none, we're now voting on drafting code 010548 and on to House Bill 849. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended.
Thank you, Mr. Chairman. What this bill does, it creates the Rural Schools Innovation Act. It creates a 2-year pilot program. This program, at least 2 rural school districts partner together to expand access to high quality career, college and career pathways training. Basically, it means that multiple schools in an area can combine and offer campus credit or CTE level. Let me back up a second. Instead of basically one school offering 3 or 4 CTE programs that are kind of average to not great, you can partner with other area schools and they can travel and the schools can combine the efforts to have like 1 or 2 great programs each that schools can then have their students seamlessly travel and have their credits still take place at their same school that they attend. And with that, I'll be glad to answer any questions.
All right. Thank you, Chairman. Members, you've heard the description of House Bill 849. Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 849, so we will have to place it behind the budget and consider it at a later date. However, since the bill has been calendared 3 times, we will need to place it on a special calendar to be published with our final calendar. And again, this is pursuant to our House rules. So without objection, House Bill 849 will go on the special calendar to be published with the final calendar. Without objection, so moved.
Thank you, Mr. Chairman.
Thank you, Chairman. All right, item number 10 on our calendars, House Bill 1607 by Chairman Howe. You have a motion and a second. Sir, you're recognized for a brief description on House Bill 1607.
Thank you, Mr. Chairman. I've got several here. I have to go through the stack. 1607 is the annual transportation omnibus bill for highways, the naming of highways and roads. It's made up of amendments given by members of the committee, put into one bill, and this is the annual bill I bring every year.
All right. Thank you, Chairman. Members, you've heard the description of House Bill 1607. Any discussion? Hearing none and seeing none, we're now voting on House Bill 1607, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 1607 moves on to full finance.
Thanks, sir.
All right. That brings us to item number 11. And item number 11 is going to be House Bill 1608 by Chairman Howe. We have a motion and a second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman, committee. This is very similar. It's the annual transportation omnibus bill for specialty license plates for various organizations who sponsor them and receive some of the funding because they sponsored that plate. This is the annual bill I bring.
All right, thank you, Chairman. Members, any discussion on House Bill 1608? Question's been called. Any objection? Call the question. Hearing none, seeing none, we're now voting on House Bill 1608, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 1608 moves to full finance.
Thank you, sir.
Thank you, Chairman. Item number 12 on our calendars, House Bill 1946 by Chairman Howell. You have a motion and a second. Looks like you have an amendment that rewrites the bill. That'd be drafting code 017355. Is that correct?
That is correct.
Okay, let's go ahead and
That's
get the
what I have.
amendment on the bill. That's the pleasure of the committee. So we have a motion and a second. Any discussion? Hearing none and seeing none, we're now voting on drafting code 017355 on the House Bill 1946. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. Sir, you're recognized.
Thank you, Mr. Chairman. The amendment was a slight change requested by TVA, which has 2 hydroelectric dams on the Ocoee River, and they just wanted us to add some language. You'll notice there in page 1 of the amendment, the whereases. That's the federal mandate that TVA has for the operation of the river. It doesn't impact the content or the context of the bill that I have. The bill was brought to me by the Ocoee Rafting Outfitters Association, and it only affects, only affects the Ocoee River. The bill has 3 parts. It allows the Ocoee River Recreation and Economic Development Board, which I chair, to work with TDEC to negotiate and pay TVA for additional water releases on the Ocoee, which hopefully will bring additional tourists to that area. And I would like to also inform the board that this board is solely funded by payments or fees from the outfitters, which is collected from those rafters who go down the Ocoee. It also caps the amount of outfitter permits that the state of Tennessee can issue on the Ocoee. And this is keeping in line with the U.S. Forest Service, in which the Ocoee River is located. There's a lot of moving parts. And it recognizes the Ocoee River as an Olympic river under the state's Scenic River Act.
All right, Chairman Howell, thank you very much for this description. Members, any discussion? Again, we're on House Bill 1946. Hearing none and seeing none, House Bill 1946 does have a cost associated with it, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 1946 goes behind the budget.
Thank you, Chairman. Committee.
All right, members, item number 13, House Bill 2804 by Chairman Halsey. I have a request here to roll this 1 week. So without objection, House Bill 2804 rolled 1 week. That brings us to item number 14. Item number 14 on our calendar is going to be House Bill 2808 by Chairman Halsey. You have a motion and a second. Chairman, it looks like you've got an amendment drafting code 016012 that rewrites the bill. Is that correct?
That is correct.
Okay, we have a motion second on the amendment. We have a motion and second on the amendment. Let's go ahead and get this on without objection. So is there any discussion on the amendment? Hearing none and seeing none. We're now voting on the amendment drafting code 016012 onto House Bill 2808. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. You're recognized, sir.
Thank you, Mr. Chairman and committee. Last year, we ran a bill dealing with HIV medicine in county jails. And inmates have HIV. And every time I fix a nice lemon meringue pie, arms of state government come stick their fingers in it and screw it all up. So we're back again this year. And this particular bill says that if the TennCare or the state health department or Ryan White has been furnishing medication for an HIV person, and then they get arrested and go into a county jail, that they will continue to pay. That's what the bill says. And with Ryan White, we had to work out a deal where the sheriff can drive somebody to the nearest doctor that sees those types of patients for that type of medication, but they were willing to do it. In my case, they only had to drive 12 miles. And I don't know if you know the cost on this. It's pretty astronomical. For each patient, it's about $3,500 a month. My county jail right now has 2. That's $7,000 or a little over $7,000. And it's killing county budgets. So it's trying to find a mechanism to give him some relief.
All right, Chairman. Thank you very much. Members, you've heard the description of House Bill 2808. Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 2808, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2808 goes behind the budget.
Thank you very
Chairman.
much.
Thank you. All right, item number 15 on our calendar is going to be House Bill 2094 by Chairman Kiesling. I have not saw the chairman, so without objection. Okay, without objection, we'll roll this to the Hill. So without objection, so moved. Brings us to item number 16, which again is by Chairman Kiesling, House Bill 2152. Again, without objection, we will roll House Bill 2152 to the Hill. Without objection, so moved. Brings us to item. Okay. All right. Item number 17 on our calendar, and I know committee and to our audience as well, we have several of these members that are presenting in other committees, so we may have to roll a couple of these down, but as they come in, we'll try to take those up, those bills up as they come in. So right now we are on item number 17, House Bill 1245 by Chairman Powers. I don't see Chairman Powers, so without objection, we will roll House Bill 1245 to the Hill. Without objection, so moved. That brings us to item number 18, again by Chairman Powers, House Bill 1248. Without objection, we will roll this to the Hill. Without objection, so moved. Item number 19, HJR 797 by Chairman Powers. Without objection, we will roll House Bill 797 to the Hill. Without objection, so moved. And that brings us to item number 20. Item number 20 is House Bill 1899 by Chairman Rudd. I don't see him. So without objection, we'll roll House Bill 1899 to the Hill. Without objection, so moved. That brings us to item number 21. Yes, sir, Representative Love.
Just checking, Mr. Chairman, are we rolling the same three sponsors?
I'm sorry, say that
I was
again.
checking, are we rolling the same three sponsors of these bills, Powers and Keys?
Yes, sir.
Okay.
Yeah.
All right, thank you.
Okay, item number 21 on our calendar is going to be House Bill. Well, he's not here as well. Okay, let's back up. I see Chairman Rudd walking in, so let's go ahead and take him up. House Bill 1899, again, that's item number 20. Item number 20 on your calendar, and Chairman Rudd will give you a second if you need to get prepared there. We have a motion to second. We have a motion to second. You're recognized for a brief description.
Thank you. This is the SRO Expansion Act that we ran during special session. It's exactly as we ran it and passed it on the House, and the Senate didn't take it up. This is really needed because it has no real physical note to it as far as state expenditures. It does qualify. It's purely permissive, and it lets the local school systems hire qualified veterans and retired police officers with training and mental evaluation. And it leaves it up to the local sheriff whether they can carry weapons, and they are an employee of the local school system. We need this because we have 500 vacancies around the state that they can't find SROs, and our children are at risk, grave risk. And we need to do this as best we can and give them some relief because they can't find enough deputies to fill these positions. And that's what the bill does. Again, it's the same as we passed out of the House and the special session, and we're running it again.
Okay, Chairman Rudd, thank you very much, members. Again, we're on House Bill 1899. Any discussion? You've heard the description. So, Chairman, I do have one. So I know this bill, as you said, we've passed it before. So this does not require that these folks be post-certified. Is that correct?
That'd be correct. They have to have minimal post 40 hours of training, but if they were post-certified, they would actually be deputies.
Right.
So the retired police officers and the qualified veterans they'd have to go and be actual deputies, and most of them don't want to be in that position.
Okay.
It would really handicap because a lot of them, some of these counties are either going to be hard pressed to find veterans and retired police officers. So we're trying to aid them as best we can.
I understand. All right. Any discussion? Again, we're on House Bill 1899. Chair Lady Hazelwood.
Help me understand, and we're all about getting these folks into our schools. We've passed some legislation, I think, just this week that Chairman Doggett had to improve this situation. I guess my concern is this just says honorably discharged veterans, And, veterans can do lots of things. They can be in lots of different categories, and they may or may not have, carried a weapon and been trained to do that. So that is my concern with that piece of it. So what kind of training would be required, whether you're a veteran or whether you're a retired law enforcement, retired law enforcement officer, I have a lot more comfort level with that, because obviously they have been through the training and all of that, have been in this sort of position before. But just opening it up to any honorably discharged veteran, that seems like a pretty broad category that you could get people that, they might be well-intentioned, but they might not have the best training or the best background. I think it takes a certain kind of character and, a certain kind of skill set in terms of human relations, if you will, to be in these positions. And so I'm just a little bit concerned about opening it up this broadly.
Well, I think that's an excellent question. And the full committee made an amendment back in special session, which is on here to address that. The plan says the expanded SRO applicants must be approved, of course, by local law enforcement to carry out firearm on campus. They also have to be approved by the LEA. They have to be fingerprinted, undergo background checks by the TBI and FBI, and they have to be evaluated by a psychologist or a certified mental health professional. And they also must be in compliance with required laws, rules, and regulations of peace officers and their standards and minimal training by the Post Commission. So we addressed that. Plus, we left it open that since they would be employees of the local school system could put additional requirements on, such as they be military, police, or whatever they want. And they may want them just to assist an SRO at their expense and not utilize any state funds and not be armed. That'd be up to the local school system. As you know, local school systems now can have security guards at their own expense, armed or disarmed. That's up to them. It's their property. And this would simply be a method, especially in the rural areas. Most of them do not have any SROs or only one, and they need help. Some of them don't even have any retired police in their counties. So this would open that up to the school system. They don't have to hire these if they don't want. It's purely permissive.
Chair Lady Hazelwood.
Again, my concern is that in our, in our great need, that we might take some people that might not be vetted as well as we would like, and I just wouldn't want there to be any unintended consequences. So, the things that you've mentioned about the additional requirements and all that give me some comfort level, but I still, just this broad category of any honorably discharged veteran remains a bit of concern. Thank you, Mr. Chairman.
Thank you, Chair Lady. Chairman Rudd, comments?
Again, we're opening this up and we're leaving that to the school system. They may not utilize this at all, or they may require additional requirements. We put very stringent minimal requirements so that we make sure the right people are on campus, but we've left the locals enough leeway so they can put additional requirements. We've only applied minimal for school safety, and I think that's there. These are veterans who have been trained. Depending on the level of training, it'll be up to the school system. Like I said, they can put a security guard in there now, but if we want to utilize any state funds, we needed to put a minimum in there for training. And I think between all the training and the minimum requirements and the evaluations that we put in there, that's more than adequate to have the veterans in our schools. And again, these are going to be employees of the school system. They're not going to put anybody in the school system they're not comfortable with.
Okay, Leader Cochran.
Thank you, Mr. Chairman. And Chairman Rudd, I wanted to reemphasize something that you mentioned earlier. It doesn't sound like you're proposing that we send people into schools with no training, right? Because I think in Section 3 of your bill, it mentions the 40 hours of basic training in school policing. Maybe some of the topics covered in that 40 hours. It says school policing, so I would say there would be some relevant topics, but I didn't know if you might know a little bit more
I
information.
don't know the
on that.
exact training. I would imagine since this is 40 hours of the minimal training that they already provide SROs, I would assume it's about crisis handling. It's about how to handle situations, how to handle individuals, how public relations, as well as what the actual laws are. They also do not have arresting power. These are not police officers. They're There are highly trained security guards to assist SROs or to assist the school system where they can't find any deputies.
Leader Cochran.
Thank you, Chairman. So yeah, just wanted to emphasize that because agreed. I do, maybe that concept of sending someone into a school with no training that causes some pause. But it doesn't sound like that's what you're proposing. You're saying that there would be post training. It's just you're not going through the 120 hours to be post certified, but you are undergoing training in school policing. And so I think that's an important point to reemphasize. Thank
Chairman
you.
Rudd.
Thank you. That's correct.
Okay, Leader Camper.
Oh, thank you, Mr. Chairman. Thank you for the bill, Representative. I was just going to reiterate the fact that the veterans are trained in weaponry, and they have to qualify every year, and there's extensive training to be qualified on your weapon. So that shouldn't be a problem. My question was around the fact that what you're trying to do is allow them to be hired under the SRO program with some alternative qualifications. Is that right? Using state funding?
Chairman Rudd.
Yes, if they can't find deputies or any qualified people, and that is a huge problem in rural areas where they usually have small police forces and they can't spare anyone to be in the schools, that this would open that up so that if they couldn't find a deputy or a trained qualified post-commissioned deputy, that they could reach out and get retired police officers or qualified veterans.
Leader Camper.
Thank you. Thank you, Mr. Chairman.
Thank you. Representative Shaw.
Thank you, Mr. Chairman. I'm sitting here listening, and I think I understand what you're trying to do, but because these men and women could face a situation that we've never heard of before, because every school incident is a different kind of situation. I'm concerned that they don't all have full training to kind of know what to do, because you're not talking about the average daily activities that they run into. I think these men and women got to be people who can think quickly at the last minute what to do. So even partial training, I'm not for sure is enough. Our babies are precious, and we need somebody who can think what to do in that moment. And because these moments going to be different, I'm not for sure. I think my problem is that enough what you're offering? Because people are going to get desperate to hire someone. They're going to need someone, and perhaps it may be someone who have some training, but just not enough in the case of a real emergency. So I just have some real concerns with that when it comes to school. We're not talking about picking up a drunk Saturday night. We're talking about incidents that could save lives in a matter of seconds. So I just really have problems with that. I don't know if you want to comment on that or not.
Chairman Rudd.
Yeah, I think the real thing is, would you rather have no one in these schools? Because that's the situation we're talking about. They can't find deputies. They can't find qualified people as far as fully trained and ready or to move to these small counties. And they're going to be unprotected. So would you rather have someone that doesn't meet 100% of your standards or meets minimal standards that could save the lives of these children? If we don't put these expanded SROs in some of these schools, they're going to be totally unguarded. And if there's a killing in that school or a shooting in that school, they're going to have no protection. And the parents are going to be wondering why they weren't protected. And this is the only way we have, because we don't have the ability to find the people that we want to be in these schools. So we have to go to retired police officers and qualified veterans. Otherwise, these children are very vulnerable and they have absolutely no protection at all. So we can either put a minimal qualified person in or no one. And that's the situation these people are in. It's not like they're going to be replacing deputies. They're going to be totally unprotected without these people. And that's what this bill is for. It's to save children's lives. Thank you.
Chairman Williams.
Thank you, Chairman Rudd. Quick, there've been several bills very similar. Matter of fact, I have one that's on the House desk now. I didn't see in here anything as it relates to an enhanced carry permit or, for instance, the bill that I had an enhanced carry permit. The reason for that is like fingerprint. you get fingerprint identification, those kinds of things. So that's how they run the background check and that kind of stuff. I guess my question is, does your bill have a provision as it relates to enhanced carry permit or any kind of fingerprint identification as it relates to similar to how our law enforcement agencies would do or any of our SROs?
Chairman Rudd.
Well, yes, Chairman, when you were out of the committee, we discussed that the bill, of course, no one could carry a weapon with the approval of the local sheriff. No one, even if they have a carry permit, can carry a weapon without the permission of the local sheriff and the LEA. In addition to that, they also have to be fingerprinted. The sheriff has to fingerprint them, undergo a background check by the TBI and the FBI, and evaluated by a psychologist and certified by a mental health professional, and go through minimal training and meet other minimum regulations and rules, sir.
Chairman Williams.
Thank you. I'm obviously supportive of your bill. I guess my only question would be the Senate companion bill for this bill is not moved in the Senate at all, and that committee has now closed. You and I had a brief discussion about that. I have an opportunity to try to communicate with the chairman of that Senate committee to see if there's a willingness to open it, and as well as the Speaker's office about whether or not there's a willingness to own that. Would you be amenable to us rolling this to the Hill so we can have further discussion? Because in this instance, this body and this committee is going to be voting on this bill, not knowing of whether or not the Senate companion is even going to be able to get heard, much less considered. Do you mind if we roll this bill to the heel of this calendar? We might get back to it a little bit more. It allowed me, because that's where I was when I was calling. I was trying to meet with the stakeholders to try to get the committee open. Do you mind if we roll it to the heel of this calendar? It would just mean you'd maybe come back in 45 minutes or something like that.
I would.
Chairman Rudd.
I would say this. Here's what I've been through at this point. The Senate sponsor has been tied up a lot of bills and forgot to put it on notice, and the committee closed it a week earlier. And we're in discussions right now with the Senate about opening up, but there's no incentive to open up if we don't pass it out on the House floor. I went to the Speaker and the leader Thursday when I found out about this, and they said, go ahead and run it. Said it'd be on them if they don't pass it. So I don't think we have any leverage for them to open it up if we don't pass it through.
Chairman Williams.
I'll leave it up to the committee, but that's where I was and where my discussion was Thursday.
Chairman Williams.
So
I would
leave
make
it up to the committee, but
I would make a request for roll this to the Hill of the committee.
Okay, that's a proper motion. Any objection to the request to the motion to roll this to the Hill? Any objection? Hearing none, seeing none, we're going to roll House Bill 1899 without objection to the Hill. So moved. All right, item number, members, I saw Chairman Kiesling come in, so we're going to take Chairman Kiesling up. Item number 15 on our calendars. Item number 15 on our calendar is going to be House Bill 2094 by Chairman Kiesling. You have a motion, a second. Sir, you're recognized for a brief description on the bill.
Okay, now the amendment is already added. Is that correct, Chair?
That is correct,
All
sir.
right, very good. This is emergency. We term this the Emergency Powers Renewal Bill. It was actually brought to me by the group First Tennessee, and Kayla Garrettson is with us actually today. And in summary, let me just give you the talking points here. Currently, the governor can issue a state of emergency for 45 days that we're aware of. But after the 45-day issuance, the gov possesses unlimited discretion to renew the emergency executive order without encountering, and I'll repeat, without encountering any checks and balances, effectively granting renewal authority for an unlimited amount of time. The proposed legislation aims to establish a system of checks and balances concerning the governor's authority to renew states of emergencies that impact, and here's where it gets into the nitty-gritty here, and it impacts 48 counties or more, ensuring accountability and oversight. General Assembly will be required, our General Assembly will be required to approve or deny any renewal or extension that impacts more than 50% of the counties in this state via a joint resolution. So the General Assembly may specify a duration for the extension of this joint resolution. Now, that's it in a nutshell. If we need to get down into a little bit
more into the weeds, I'm out, and I have got a request for, I think, Chairman, request testimony here by Ms. Garrettson if the committee so chooses, but that I would need her to help me from this point forward.
All right, Chairman, thank you very much. Again, members, we're on House Bill 2094. Let's go to the sponsor first. Any questions for the sponsor on the description? We do have someone that is here to testify as needed. If you would like to hear from her, I'm going to let that be to the will of the body. I'm not hearing or seeing any questions. I'm not seeing any requests for the speaker to come forward. All right, so we're going to move on. House Bill 2094, Chairman, it does have a cost associated with it, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2094 goes behind the budget. Thank you, Chairman. All right, members, that brings us to item number 16. And let me let Representative Gillespie know you are on deck, sir. So I know he needs to get out of here in just a second, so we'll pull you up next. Item number 16 on our calendar is going to be House Bill 2152 by Chairman Keesley. We have a motion to second. Sir, you're recognized.
All right. Thank you. Thank you, Chairman. Yes, House Bill 2152 has local application there in Scott County. It's regarding our general sessions. Both Senator Yeager and I did receive a resolution from the county commission over there dated late February that is requesting it requires the judge of their general sessions court in Scott County to devote full time to the duties of said office and prohibits the judge from the practice of law and any other employment which conflicts with the performance of their duties as judge. So that is it, and I'll renew.
All right. Thank you, Chairman. Members, you've heard the description of House Bill 2152. Any discussion? Hearing none and seeing none, we're now voting on House Bill 2152, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 2152 moves on to full finance.
Thank you. Thank you, Chairman and members. Thank you.
All right, members, let's jump over to item number 28. Item number 28 on our calendar again is going to be by Representative Gillespie. All right, item number 28, House Bill 1718 by Representative Gillespie. We have a motion and a second. You have a motion and a second. You're recognized for a brief description.
Thank you, Mr. Chairman and committee. This bill is pretty simple. What it simply does is if you are arrested and the judge grants you bail and there are conditions placed on that bail, then those conditions would have to be monitored on a 24/7, 365-day basis. Because what's happening now in certain counties, this only applies to places that already have this infrastructure in place with pretrial monitoring. And what happens now is a lot of these times they're only monitored Monday through Friday, 8 a.m. to 5 p.m. And I think, as we know, a lot of crimes happen in other hours of the day and on weekends. And then this also would require that if you do break those conditions, that you would go back to jail. And with that, I welcome any questions.
Okay, thank you very much, Representative Gillespie. Members, you've heard the description of House Bill 1718. Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 1718, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 1718 goes behind the budget. Brings us to item number 29. Item number 29 on our calendars, House Bill 2814, again by Representative Gillespie. Do we have a motion to second? We have a motion to second. Sir, you're recognized for a brief description.
Thank you so much, Mr. Chairman and committee. This one's even simpler. All we're doing here is increasing the penalty for drag racing or organized street racing from its existing Class A misdemeanor, which we did a couple years ago, to a Class E felony. Still a huge issue all across the state. Unfortunately, people are dying as a result of it, and I ask for your support. With that, I welcome any questions.
Okay, thank you, Representative Gillespie. Again, members, we're on House Bill 2814. You've heard of the description. Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 2814, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2814 goes behind the budget. Thank you, Representative Gillespie.
Thank you for coming.
That brings us to item number 30, which was also by Representative Gillespie, HJR 685. I've got a request here to take this off notice. So without objection, HJR 685 is off notice. So moved. Thank you, Representative. All right, that brings us back to item number 21. Item number 21, that's Chairman White's bill, but Chairman Whitson's going to actually run that for him. So item number 21 on our calendar is going to be House Bill 2677 by Chairman Whitson. You have a motion to second. You're recognized, sir, for a brief description.
Thank you, Mr. Chairman, and I signed on as a co-sponsor with the clerk's office earlier. This bill will increase the annual continuing education requirement for county commissioners from 7 to 8 hours and requires the training to be attained at the University of Tennessee's County Technical Assistance Service conferences or meetings. It extends a $600 stipend to county commissioners for completion of the annual training. With that, I renew my motion.
Thank you, Chairman. All right, members, you've heard the description of House Bill 2677. Any discussion? Representative Shaw.
Well, there we are. Thank you, Mr. Chairman. The stipend, who pays that? I like your bill, but who pays that?
Chairman Whitson.
The County Commission Association voted unanimously to absorb the costs.
Thank you.
Thank you. Further discussion. Again, we're on House Bill 2677. Hearing none and seeing none, there is a cost associated with House Bill 2677, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2677 goes behind the budget. All right, members, that brings us to item number 22 on our calendar. Item number 22 is going to be House Bill 2174 by Representative Alexander. We have a motion to second. Representative Alexander, looks like there is an amendment, drafting code 017269 that rewrites the bill. Is that the correct amendment?
That is, I've got
17269.
017100.
That is not.
Is that the latest one? No, you all got the.
Yep, you withdrew that one
Yes,
that you just
and-
referenced, and the new one
Okay.
that you filed was 17269.
Okay, thank you
Okay,
very much.
you have a
Sorry.
motion to second. It does, again, rewrites the bill. You have a motion to second on the amendment. We'll go ahead and get the amendment on if that's the will of this committee. So any discussion to the amendment? Hearing none and seeing none, we're now voting on drafting code 017269 onto House Bill 2174. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. You're recognized.
Okay, basically what this bill does is just allow for businesses that are not normal food selling establishments to go to a 2-day instead of a 1-day ability to sell food out in front of their establishment. A tire store, for example, sells water and candy and cookies and chips during Storytelling Festival. That's what this does. It just
All
goes to a 2-day thing. I've worked with the Department of Health on this, and they're all good with it. They put the last amendment on it.
Okay, all righty. Members, you've heard the description again of House Bill 2174. Any discussion? Hearing none and seeing none, we're now voting on House Bill 2174, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 2174 moves on to full finance. Thank you.
Thank you all.
All right, that brings us to item number 23, and waiting patiently in the back of the room is House Bill 1978 is Representative Capley. You have a motion to second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman. Thank you, committee. House Bill 1978 makes burglary of conveyance a Class D felony. That's what the
All
bill
right,
does.
thank you, Representative Capley. Members, you've heard the description. Any discussion? Hearing none and seeing none, House Bill 1978 does have a cost associated with it, so we will have to place it behind the budget, consider it a later date. So without objection, House Bill 1978 will go behind the budget.
Thank you, Mr. Chairman.
Capley. That brings us to item number 24, House Bill 1911 by Representative Bolso. You have a motion to second, sir. You're recognized.
Thank you, Mr. Chairman. Good afternoon, members of the committee. Tennessee has a statute that criminalizes unlawful photography, which occurs, for example, where someone takes a phone and surreptitiously photographs the intimate areas of another person for that person's sexual gratification or sexual pleasure. Currently, that constitutes a Class A misdemeanor. This bill, if enacted, would take the Class A misdemeanor and kick it up to a Class E felony, and the other penalties set forth in the statute would increase depending upon the severity of the crime and the aggravating factors.
Okay, thank you, Representative Bolso, for this description. Members, any discussion? Again, we're on House Bill 1911. Hearing none and seeing none, there is a cost associated with House Bill 1911, so we will have to place it behind the budget, consider it at a later date. So without objection, House Bill 1911 goes behind the budget. Thank you, Representative. All right, that brings us to item number 25. Item number 25 on our calendars, House Bill 2158 by Representative Davis. We have a motion to second. Looks like you've got an amendment drafting code 017217, which rewrites the bill. Is that correct? All right, you have a motion second on the amendment. no objection, we're going to go ahead and try to get this amendment on. So any discussion on the amendment? Hearing none and seeing none, we're now voting on drafting code 017217 onto House Bill 2158. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. You recognize.
Thank you, Mr. Chairman, and thank you, committee, excuse me. So essentially, with the amendment, it rewrites the bill to change this to be a study only so that we will gather some information with regard to the number of nurses that are contracted by our LEAs, and then also gather some more data as to how many chronically ill students we have. And that way we can really evaluate the need and necessity of reducing the ratio from 1 to 3,000 students down to more of 1 to 750 students for a nurse in every school.
All right.
With that amendment, it does change that fiscal note to not significant.
Okay. Thank you very much. Any discussion? You've heard the description. Chairman Hall.
Thank you, Mr. Chair. Representative Davis, thank you. We've worked on this for a long time. I've been at it for 7 years, 8 years now, and you've been since you've been in office. So I appreciate the awareness that we're continuing to bring to the need for nurses within our school districts and the health of our students therein. So thank you for this work. Thank you, Chairman.
Thank you, Chairman.
Thank
Representative Davis, any comments from you? All right, further discussion. Hearing none and seeing none, we're now voting on House Bill 2158, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 2158 moves to full finance.
Thank you, Chair. Thank you,
Representative.
committee.
All right, that brings us to item number 26 on our calendar. It's going to be House Bill 2055 by Representative Eldridge. I do not see him, so without objection, we will roll House Bill 2055 to the Hill. 27, item number 27 is going to be House Bill 1872 by Representative Fritz. I don't, so, yep, there he is. You have a motion and a second. Again, we're on House Bill 1872 by Representative Fritz. You've got a motion and a second. We will recognize you for a brief description. You are recognized.
Thank you, Mr. Chairman. Oh, I'm sorry. The bill, thank you. The bill before you does 4 basic things. It increases enhances the penalty or allows for enhancement of penalty for illegal aliens who commit felonious violent crimes in the state of Tennessee. It allows for enhancement of penalty for those who are in possession of a deadly weapon in commission of that crime. It also addresses any adult who goes on a K through 12 school while children are present, and it enhances that penalty up to life in prison, and allows the magistrate to consider the residency of the person in admission of bond. With that, I'd take any questions you have.
All right, Representative Fritz, thank you very much. Again, members, we're on House Bill 1872. Any discussion? Chairman Williams.
Interesting question. Thought I would ask you. Texas recently passed a law that allowed them to deport folks that committed these kinds of crimes if they were not a citizen of the United States. Did you look at that by any chance to see if if that might be a better remedy than incarcerating someone for, as far as the cost of the state, rather than incarcerating for somebody for 25 years?
Representative Fritz.
Thank you, Mr. Chairman. Thank you for the question. I did consider that. I thought that would be a bar too high, to be honest with you, with to be able to get to the deportation, because there would be a cost with that as well.
Right.
And the cost, the fiscal note on this doesn't come into effect, I think, until 30/31. To be honest with you, committee, my primary emphasis on the illegals is to address the invasion that we have at our southern border by making Tennessee a little less favorable residency place for those who plan to come here and commit violent crimes.
Chairman Williams.
Well, I might argue if they knew they'd have to go back to where they came from, they definitely would. It would be a deterrent.
Sure.
But anyways, just a thought. Thank you.
All right, further discussion. Again, we're on House Bill 1872. Hearing none and seeing none, there is a cost associated with House Bill 1872, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 1872 goes behind the budget.
Thank you.
Thank you, Representative Fritz. All right, members, we're going to jump back one spot to item number 26 on our calendars, House Bill 2055 by Representative Eldridge. Sir, you have a motion and a second, and you are recognized, Representative Eldridge, on House Bill 2055 for a brief description.
Thank you, Chairman and committee, and I apologize for the delay. We're playing musical chairs with Chairman Kiesling. This bill it authorizes the assessor to determine permanent value records, allows for tax maps and other documents to be electronically scanned by the Register of Deeds office using funds allocated to preserve permanent value records. that originate in the assessor's office. It will clarify for the assessors how to deal with movable structures that are constitutionally required to be assessed based on their use, and it will also authorizes a continuous review cycle for visual inspection, and this will allow for the counties to save money when the State Board of Equalization approves its use, and that's what the bill is about.
All right, Representative Eldridge, thank you very much. Members, any discussion? Again, we're on House Bill 2055. Hearing none and seeing none, we're now voting on House Bill 2055, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 2055 moves on to full finance.
Thank you, Chairman
Thank
and
you,
committee.
Representative Eldridge. All right, members, we're going to hop now back over to item number 31. Item number 31 on our counter is going to be House Bill 2954 by Representative Hardaway. You have a motion and a second, and Representative Hardaway will let you describe the bill, and then I see that you've got some folks here to give a testimony, and then we'll jump over to them. So we'll let you go first, though. Describe the bill. You have a motion second.
Hold on just a minute, sir. My computer is going on the blank. All right, thank you, Mr. Chairman. House Bill 2954 enacts a prostate-specific antigen screening for high-risk Insured Men Act, which requires health insurance coverage for the early detection of prostate cancer, early detection for the detection of prostate cancer for men who meet certain risk criteria or age thresholds. And I emphasize early, that's when you can mitigate it and hopefully cure it.
All right. Thank you, Representative Hardaway. Members, you've heard the description of House Bill 2954. We'll go to the sponsor first to see if there's any questions for him. Are there any questions? Again, we're on House Bill 2954. I don't see any, so we do. Oh, Chairman Whitson, I'm sorry.
Thank you, Mr. Chairman. This is great legislation. I had two of my officers that work for me. They went in for their flight physical. One was 38 and the other one just turned 40. And they, through their PSA test, they found out they had prostate cancer. It saved their lives. And thank you for bringing this.
Thank you, sir. Thank you. Further discussion again, and we'll come back to the sponsor once our folks testify. So without objection right now, we're going to go out of session. So without objection, we're out of session, and we're going to go ahead and call up Kelvin Moses. And do we have, is your guest speaker here, Representative Hardaway? We're good?
No, sir.
Okay.
I think I got a good shot at this.
I don't know. I don't see anybody else. I guess, is there anybody here that's on the list that wants to testify? Let me open that up. I think you're in a good spot, Chairman. Okay. Okay. If you would just please come up to the mic. Once you turn the mic on, just make sure you state your name and your affiliation. Thank you very much for being here. You have 3 minutes. Hit that one more time.
More time?
There you go.
There we go. Okay. I'll try to make it quick. Good morning. I'm Maddie Michael. I am the Government Relations Director here in Tennessee for the American Cancer Society Cancer Action Network, an organization dedicated to advocating on behalf of public policy to end cancer as we know it for everyone, testifying in strong support of HB 2954. In 2024, it is estimated that 6,150 men in Tennessee will be diagnosed with prostate cancer, and 750 men will die from prostate cancer. Some men are at higher risk of developing prostate cancer than others, including men who have had first-degree relatives who have been diagnosed with prostate cancer, and African-American men. Having a first-degree relative who has had prostate cancer more than doubles your risk of developing the disease. And African-American men in the United States have among the highest documented prostate cancers rates in the world, and their cancer disparities are one of the greatest mortality disparities in oncology. Prostate cancer survival rates increases when detected early, as Representative Hardaway said. However, there has been a recent increase in diagnosis with men who have advanced prostate cancer. Screening can help detect prostate cancer at an early stage, often before any signs or symptoms are presented and before the disease becomes more advanced and more difficult to treat. However, cost sharing and out-of-pocket requirements can be a barrier to accessing screening. HB 2954 helps ensure all men with high risk for prostate cancer who decide to move forward with the screening after discussion with their healthcare provider are able to get the screening and treatment for prostate cancer and should be able to access the screening that is barrier-free and without cost sharing. Cancer not only takes a huge physical toll on people facing the disease, but also comes with many financial costs. You have the chance to ensure men across Tennessee who need these screenings are able to receive them. We urge you to vote yes on HB 2954 to further protect the health of Tennesseans. Thank you very much and for your time and consideration.
All right. Thank you very much. And we'll see, does anyone have any questions for our guests today? I don't see anyone. Thank you so much for being here. So without objection, at this time, we're going to go back into session. I don't see any objection. We're back in session. And Representative Hardaway.
Mr. Chairman and members, this is comparable to the years of information and involvement that I've gotten from breast cancer for women. Okay? The same way that awareness early on enables more mothers, sisters, daughters, aunties, nieces to be around in the lives of their family, so will this allow fathers and brothers and grandfathers and sons and cousins and nephews to be around for the full life that their family and their friends deserve for them to have and to have with them.
All right. Thank you, Representative Hardaway. Further discussion. Hearing none and seeing none. We're now voting on House Bill 2954, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 2954 moves on to full finance.
Thank you, Mr. Chairman. Thank you, members.
Thank you. Brings us to item number 32, which is House Bill 2959, also by Representative Hardaway. You have a motion second, sir. You're recognized for a brief description.
All right. How's that captioned, Mr. Chairman?
That was correctional programs.
Oh, Mr. Chairman, once again, we're looking at something that will save millions. That's only going to cost us a little. This came to me, this is about developing parenting plans for those who are incarcerated, both mothers and fathers, so that they can be that positive influence in their child's life, even while they are behind bars. The facts are that the children of incarcerated parents are highly more likely to follow their parents into the justice system. With that brief description, Mr. Chairman, I would urge you to skip the budget and let's move this on to high finance.
All right, members, you've heard the description of House Bill 2959. Any discussion on the bill? Hearing none and seeing none, there is a cost associated with House Bill 2959. So we will, yes, sir, you're recognized.
Mr. Chairman, there's a cost associated with not having this bill.
Well said, well said. Meanwhile, there's a cost associated with House Bill 2959. So we do appreciate you bringing this bill forward. So we will have to place it behind the budget at this time and consider it at a later date. So without objection, House Bill 2959 goes behind the budget. Thank you, Representative
Thank you, Mr.
Hardaway.
Chairman. Thank you, committee members.
All right, item number 33 on our calendar is going to be House Bill 416 by Representative Hemmer. I do not see the. Okay. All right, House Bill 416, we got a request to roll him to the Hill. So without objection, so moved. That brings us to item number 34. Item number 34 is going to be by Representative Raper. It's going to be House Bill 2477. I don't see him. Without objection, we'll roll House Bill 2477 to the Hill. That brings us to item number 35. Item number 35 is Representative Sparks, House Bill 2062. You got a motion and a second. You're recognized for a brief description, sir.
Thank you, Chairman. Thank you, members. Members, House Bill 2062 is a simple bill. It just creates a street racing task force to determine the best practices to curb the illegal street racing that we've seen a rash of across our state. And like I said, pretty simple bill. Governor Greg Abbott of Texas They implemented something very similar, sir.
Okay, thank you very much, Representative Sparks. Members, you heard the description. Any discussion? Again, we're on House Bill 2062. Hearing none and seeing none, House Bill 2062 does have a cost associated with it, so we will have to place it behind the budget and consider it at a later date. So without
Thank you, Chairman.
objection,
Thank you, committee.
House Bill 2062 goes behind the budget. All right, that brings us to item number 36. Item number 36 on our calendars, House Bill 2743 by Representative Stevens. We have a motion second. We have a motion second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman. This bill seeks to ensure that military families can receive the benefit of in-state tuition should a reassignment result in a temporary family separation. This bill requires that both the service member and dependent be U.S. citizens and lawful permanent residents, and the legislation mirrors the one-year residency requirement for in-state tuition rates, but applies the residency requirement to the service member rather than to the student.
Okay, thank you, Representative Stevens. Members, you've heard the description. Any discussion? Again, we're on House Bill 2743. Hearing none and seeing none. There is a cost associated with House Bill 2743, so we will have to place it behind the budget, consider it at a later date. So without objection, House Bill 2743 goes behind the budget.
Thank you.
Thank you, Representative. Item number 34 on our calendar, we're going to back up and get House Bill 2477 by Representative Raper. We have a motion to second. We have a motion to second, and Representative Raper, you are recognized, sir, on House Bill 2477 for a brief description.
Thank you, Mr. Chair and committee. Give me just 1 second. The purpose of this bill is to assist local agencies in hiring EMTs. We have a big shortage around the state, especially in Bradley County and Cleveland area where we are. At one time in post-COVID, we got down from 16 employees down to 7. And so we're trying to get as many certified as paramedics as we possibly can. What this bill would do is it would reimburse anyone that is taking the test a one-time reimbursement, and that just pretty much is the extent of it. So I'm open to any questions you may have.
All right, thank you, Representative. Members, any discussion on the bill? You've heard the description. Hearing none and seeing none, there is a cost associated with House Bill 2477, so we will have to place it behind the budget, considered later date. So without objection, House Bill 2477 goes behind the budget.
Thank you, Mr. Chair and committee.
Thank you, sir. All right, let's jump over to item number 37 on our calendar. It's going to be House Bill 2597. I've got a request here to take House Bill 2597 off notice. So without objection, House Bill 2597 off notice. Brings us to item number 38. Item number 38 on our calendar is going to be House Bill 2099 by Leader Cochran. You have a motion, a second. And it looks like, sir, you have an amendment drafting code 017089.
That's correct, Mr. Chairman.
Okay, we have a motion, second on the amendment. You have a motion, a second. You want to describe the amendment?
Yes, sir. Mr. Chairman, stand by 1 second if you don't
fine.
mind. Thank you. And so the amendment essentially is, let me give you a brief background on the bill to explain the amendment. We are implementing an option for a different fee for district attorneys to collect. The fee that used to be collected was on bad checks, right? So any type of court case regarding a bad check, no one writes those anymore. So this is allowing a county to implement a new fee to replace the previous one. The amendment, Section A, this section takes effect in any county immediately upon approval by 2/3 vote of the county legislative body. The second part of this amendment will have the district attorneys, the DA's conference submit a report on how these funds are used.
All right, members, you've heard the description of the amendment. Again, we are on the amendment. Any discussion on the amendment? Chair Lady Hazelwood.
Thank you, Mr. Chairman. I'd just like to thank the sponsor for considering this amendment. We had a good deal of discussion about it, and I think it makes the bill better. So thank you so much.
Thank you, Chair Lady. Leader Cochran.
Of course, no, happy to work with you. Thank you.
All right. Thank you. We're still on the amendment. Any further discussion? Hearing none and seeing none. We're now voting on Amendment Drafting Code 017089 on to House Bill 2099. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. We're back on the bill as amended. And Leader, you have the floor.
Thank you, Mr. Chairman. Again, not a lot of additional explanation. In 1984, this is when this initial fee was implemented, and it was on, again, those cases regarding bad checks. That doesn't really happen anymore, so this is giving counties an opportunity to replace that fee with like another, it's a $12.50 fee to take the place of the old one. And
All right.
I'll yield any questions.
Thank you, Leader. Members, you've heard the description. Any discussion? Leader Camper.
Thank you, Mr. Chairman. Representative Leader Cochran, you said initially, prior to this, it was on bad checks. And this is on every single charge. Okay, so this is on every single charge. And I'm curious about how much a difference of money are we going to be collecting when I don't know if a lot of people was writing a lot of bad checks and charging a fee for that versus every single case that's filed. So I'm trying to get a sense of what you think the difference might be in the amount of money we were collecting and the amount of money we will be collecting the way you have it structured now.
Leader Cochran.
I'm looking for them.
Thank you, Mr. Chairman and Leader Camper. So kind of the point. So in the 80s, when this was when this was initially implemented, there were a lot of those cases. Again, at that time, you had a lot of people writing checks, and as we've moved into a more digital age, that has reduced greatly. So this is to provide some replacement funding to bring it back up to those previous levels. Again, to receive the funding that it used to receive in previous decades. I can't give you an exact difference or perhaps how much that fund would grow. But this would be for the purpose of defraying the cost of legal representation and support services provided. It's $12.50 is collected on every misdemeanor and felony prosecution is what this would propose.
Leader Camper.
And did you say what the money would be used for?
Leader Cochran.
Yes. So it's enacted to a fraud and economic crime fund. That the intent behind the fund was stated to provide district attorneys general of the state with the resources necessary to deal effectively with fraud, economic, and other crimes. The economic crime fund has been necessary to supplement for many purposes within the DA's offices across the state. The funding formula for the act, again, as we talked about, was based on worthless checks. But in general, to provide district attorneys general of the state with the resources necessary to deal effectively with fraud, economic, and other crimes, and that's current code. That's how our code currently lists that.
Leader Camper.
Okay, thank you, Leader.
All right, thank you. Further discussion. Again, we're on House Bill 2099. Hearing none and seeing none, we're now voting on House Bill 2099. Moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 2099 moves on to full finance. All right, that brings us to item number 39, House Bill 2240 by Leader Cochran. We have a motion. We have a motion, a second. We have an amendment on this bill. Looks like it rewrites the bill. So let's go ahead and try to get this amendment on. Drafting code 017260. Is that correct, Leader?
That's correct, Mr. Chairman.
All right, we have a motion, second on the amendment. You have a motion, a second. Any discussion on the amendment? Chair Lady Hazelwood.
Thank you, Mr. Chairman. This amendment, I've just this morning had some contacts from some of my folks back home who had some, I think this amendment was put on the Senate maybe yesterday or whatever. And they had some concerns that the amendment was, taking away a lot of the effectiveness of the bill and would inhibit the intent of the bill. I think one of my colleagues used a phrase yesterday that I'll steal. It was, this bill started out a tree and this amendment would make it a toothpick. So I have not had time to, delve into it. So I just like your thoughts and your explanation of the reason for the amendment. And if you can make me more comfortable about that.
Leader Cochran.
Sure. Thank you, Madam Chair Lady and Mr. Chairman. So the one that was potentially being considered in the Senate, I believe is the one that they might have had concern about, may be different from this one. It was regarding counties that may or may not be grandfathered in under an old hotel motel tax system. This one is really just kind of the one, it's the one getting rid of the fiscal note of any cost. It's still making clear that that counties are submitting a report to the comptroller to show how their hotel motel taxes are being spent. That's what this bill still does. just speculating, but it might have been that Senate amendment that they were asking a question about.
Okay, again, and I apologize. I got
No.
the text this morning
Sure.
and it's been a bit busy, but if you're assuring me that our tree is still a tree, then thank you.
I think it's still a nice looking tree, Madam
Thank
Chairlady.
you.
Yes, ma'am.
Chairman Williams.
Thank you. So while we're on the amendment, tell me, I'm not saying I don't like your bill, but no one in my community likes your bill. So could you tell me what your amendment does that might improve my ability to like it?
Leader Cochran.
Sure. Well, and I will do my best. This is really all this one does. And I want to be clear, this is also and maybe this is another point to make on this amendment. It is taking out, I don't know if perhaps your community is seeing a section 2 on this that is actually, originally there was a portion of this bill that talked about percentages of the hotel motel tax, like the amount of a hotel motel tax you could implement. That was taken out in sub. That there was through a sort of a mishap in full committee that amendment did not follow with it. So this also takes care of that. And so I know that there were some communities that were concerned about like it limiting their amount of hotel motel tax, that this bill had anything to do with that. That's also what this amendment does. It's making it clear that section 2 is removed, removes the fiscal cost. So really all we have left with now is a reporting bill. It's just saying that you are submitting, counties keep, kind of putting my day job hat on for just a second. We keep up with how we spend that hotel motel tax money already. It's we're just, you're basically just looking in the budget and you're saying, hey, this line item, and you're just submitting that to the comptroller annually. So it's information that we already collect. We're just reporting it. And so, but I'll yield any other questions they may have about it.
Chairman Williams.
Thank you. So previously, the disdain was around the fact that my community could not continue to levy the same hotel motel tax that we previously did. You're saying that language is not a part of this amendment.
Leader Cochran.
Thank you, Mr. Yeah, absolutely. No, that this bill has nothing to do with how they. If you're, and I'll make an example. Actually, my community is one of those that we are under. A previous private act where we use a large portion of our hotel motel tax, McMinn County does, on industrial development. There's still a big portion that's used on tourism, but there's also a sizable portion on industrial development. We will still do that. This does not change that at all. This is just saying however you spend it, it's just you're submitting a report, but it absolutely does. If you're under a formula similar to that where you do industrial development and tourism, you will still do that. Trust me, or I wouldn't be carrying this bill.
Okay. All right. Thank you very much.
All right. Further discussion. Again, we're still on the amendment. Hearing none and seeing none, we're now, motion has been called on the amendment. And any objections to calling the question? I get my cadence back here. You got me confused with the Christmas tree. I'm wondering now if we're back down to a post. I'm trying to figure this out. All right, we're on the amendment. No more discussion. So we're now voting on amendment 017089 on the House. Nope. 017260 on the House Bill 2240. All those in favor of putting on this amendment signify by saying aye. All those opposed, no. The ayes have it. We're back on the bill as amended. And Leader Cochran, you are recognized.
Thank you, Mr. Chairman. And since that amendment rewrites the bill, I think we've kind of covered the details. Again, this is a report. So it absolutely will not change any way that any local government collects their hotel motel tax or how they spend the hotel motel tax. Again, if it did, I would not be carrying it.
All right. Thank you, Leader Cochran. Members, any further discussion? Again, we're on House Bill 2240. Hearing none and seeing none, we're now voting on House Bill 2240, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 2240 moves on to full finance. Thank you, Leader. All right, item number 40 is going to be House Bill 2538, also by Leader Cochran. Do we have a motion and a second? You have a motion and a second. You're recognized for a brief description.
Thank you, Mr. Chairman. I do have an amendment unless it's traveling with it.
It is traveling.
Okay,
You are in the proper posture.
Thank you very much. Members, we've talked about this. We've seen maybe a couple bills dealing with this issue of threats of mass violence. currently in code, really the only place where we have a charge for a threat of mass violence is in relation to a school. This is expanding that, where if you are making a threat of mass violence, which an incident of mass violence would be where you're threatening to harm or kill 4 or more people. It doesn't matter if it's a shopping mall, public park, whatever. That we right now in code, there's really only a misdemeanor charge for the threat. And so there's either that or there's a felony charge of like a threat of a terrorist act. And I may not have that title exactly correct, but that one is very tough to prosecute. So DAs have a hard time making that stick. This is giving somewhere in between. This is giving them an additional tool. So if someone is making a credible threat of mass violence, that there's a felony charge for that. You shouldn't just be able to flippantly do that. And I do want to make this just for the record. I think an important distinction here in the bill's current posture. We've increased a person making a reckless communication to one making a knowing communication. And that's a higher legal threshold. So make sure that we're not getting someone who did just make an offhanded comment. Would be someone who is seriously intending on committing the act. I know that there's a cost associated, so we know where this will have to go for a while. But I think that this would be an interesting and I think an effective new tool for us to use. And I'll yield any questions.
All right, Leader Cochran, thank you very much. As the leader has alluded to, it does have a cost associated with it, but any discussion before we do put this bill behind the budget? Hearing none and seeing none, without objection, House Bill 2538 goes behind the budget.
Thank you, Chairman and Committee.
Thank you. Let's jump back to item number 33. I see Representative Hemmer has come in. You have a motion and a second, Representative Hemmer. And again, members, we're on item number 33, House Bill 416. You're recognized, sir, for a brief description.
Thank you, Mr. Chairman, members of the committee. House Bill 416 is dealing with PACE, and it's a really interesting program that's been operating actually in Hamilton County for nearly 30 years, actually predates TennCare. And so all this bill and through the amendment we'll be doing will allow that existing facility to expand to the neighboring counties, but also allowing TennCare to expand this program nationwide or statewide.
All righty. I'm glad I'm not the only one out in front of their skis a little bit today. All right, members, you've heard the description. Again, we're on House Bill 416. Any discussion? Oh, Chair Lady Hazelwood.
I just want to put in a plug for PACE. They do a great job, and it's a cost-effective methodology for providing these kind of services. I know we can all see the price tag here and know what's going to happen, but being able to, it's another one of these bills that might cost money up front, but it should save us money in the long run.
All right. Thank you. Thank you very much. Further discussion. Again, we're on House Bill 416. Hearing none and seeing none, as the chair lady has alluded to, there is a cost associated with House Bill 416, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 416 goes behind the budget. Thank you, Representative. Members, that takes us back to item number 41. Item number 41 on our calendar is going to be House Bill 2120 by Chairman Faison.
Thank you, Mr. Chair.
You have a motion second. You're recognized.
Thank you. Mr. Chairman, is the amendment traveling or do we need to adopt the
Yes,
amendment?
sir. It is traveling, so you are in the proper posture to move forward.
Okay, briefly, members, the amendment does not write the bill, but it does take TDEC out of this. You remember, maybe you don't remember, but a week or so ago, I passed a bill about eminent domain that puts some guardrails on what a local condemner can do. This bill is in comparison with that it just takes the term recreational purposes out of public use. Right now, our law, even after we pass it, it gives some ideas of what you can use eminent domain for, and they call it public use. We're just saying that you can't take somebody's property if the reason you're taking it for is for a recreational facility.
Okay, thank you very much. Members, you've heard the description of House Bill 2120. Any discussion? Hearing none and seeing none, there's a cost associated with House Bill 2120, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2120 goes behind the budget. Brings us to item number 42. Item number 42 on our calendar is going to be House Bill 2729, again by Chairman Faison. You have a motion to second, sir. You're recognized.
Thank you, Mr. Chair and committee. This is brought to us by our public defenders. The driver's license that have been revoked for DUI for the first year and for a first offense. That happens when you get a DUI, you lose your driver's license for a year. The revocation of a person's license treated a bit differently than other forms when the revocation happens. To be clear, the bill does not affect DUI law in any way, but at the end of a year, the person is eligible to have their driver's license reinstated. What we've seen is that there are times that they just don't have the money to pay for the fees. You have to pay for those fees. This allows the judge's discretion to not, if they get picked up even 2 years out, and they're eligible for their license to be renewed, they're automatically locked up for up to 6 months. This just allows the judge to look at this and waive that and not mandatory put them in jail. If they're actually on the right track, they've got a job, and if this would impact their job, it gives the judge discretion to not lock them up for what the current law says.
All right. Thank you, Chairman. Members, you've heard the description of House Bill 2729. Any discussion? Chairman Hawk.
Thank you, Mr. Chairman. I think seeing the disposition of the last bill, the caucus chair needs to ask his son if he thinks this bill is okay and if this bill may pass. He doesn't have to speak on the microphone, but Tucker, do you think this bill should pass? Yes or no? Okay.
I like him already.
Thank
So,
you, Chairman and members.
all right. With that said, unless someone has objection, we're going to place House Bill 2729 behind the budget, considered a later date after consulting with Tucker. So any objection? Seeing none, House Bill 2729 goes behind the budget. All right, that brings us to item number 43. Item number 43 on our calendar is again House Bill 2732 by Chairman Faison. You have a motion to second.
Thank
You're
you,
recognized.
Mr. Chair. And the amendment is traveling with it. Is that right?
Yes, it is, sir. You're
Right
correct.
on. Bill does three things: provides CWA appropriate authority to manage Lake Hartford and its unique amenities as well as other agency lakes, consistent with community expectations. Makes clarification that a possession permit is not also required if you have a propagation permit. It sounds really complicated. It's not. I'll go deep in the weeds if you want me to, but it's kind of a clarification bill for TWA.
All right. Thank you very much. Members, you've heard the description. Again, House Bill 2732. Any discussion? Any discussion? Hearing none and seeing none, there is a cost associated with House Bill 2732, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 2732 goes behind the budget. All righty. That brings us to item number 44. Item number 44 on our calendar is going to be House Bill 1184 by Representative Garrett. I do not see Representative Garrett, so without objection, we'll roll House Bill 1184 to the hill. That brings us to item number 45. Item number 45 is going to be by Chair Lady Hazelwood, House Bill 1614. You have a motion and a second. You are recognized.
Thank you,
Okay,
Mr.
hold on.
Chairman.
Chair Lady, hold on one. All right, members, let's back up 1 second. I hear what the chatter was about now, Representative Faison, and I apologize. We are, again, going to go back to item 42. We're going to go back to item number 42, and we're going to reconsider our action. So without objection, we're going to reconsider our actions on House Bill 2729. Without objection, seeing none, we're back on the bill. And at that time, this bill is actually ready to move out. So I apologize for that.
We
So
accept your apology and look forward to your positive vote, sir.
we're one gavel away from putting it back behind the budget. So, all right, members, we're back on the bill. I apologize for that. So again, we're on House Bill 2729. Leader Camper.
Thank you, Mr. Chairman. Tucker did say so far yes on the bill. Is what you missed that part.
I did.
He said
Yes.
so far yes.
Yes. Okay. I
Move
did
it
miss
out.
that. I missed that. All right. I think we just got a call to the question. So I hear no
Question on the
objection. So
bill.
there we go. So we're now voting on House Bill 2729 to move on to full finance. So all those in favor signify by saying aye. All those opposed, no. The ayes do have it. House Bill 2729 moves on to full finance. Thank you, Tucker. All right, let's move to item number 44. Item number 44 on our calendar is going to be House Bill 1184 by Representative Garrett. Again, that bill we put to the hill, so we're going to move on to 45. Item number 45 is House Bill 1614. Chair Lady, you have a motion and a second. You are recognized on House Bill 1614.
Thank you, Mr. Chairman. This is the bill that would require companies that provide pornographic access to pornographic materials online. They would be required to verify that the person viewing that is of age. It is simply a match in the cyber world to what we already do in the physical world. We don't allow children under 18 to access to go into adult entertainment. It's in, locations or to purchase magazines or other things that are pornographic nature. The cyber world is a bit different, but this would require that same level of scrutiny before young people could access this. And I might mention that 7 states have similar legislation in place. And there's a crying need for this. There's been studies done, and a huge percentage of kids that are 73% of teens between 13 and 17 admit that they've watched have seen pornographic materials online. 54% said that they first watched it before they were 13 years old. So again, I know the fate of this bill at the current time, but I hope this is one that we can look into funding as we move forward, because I think it's sorely needed. Thank you.
All right. Thank you, Chair Lady. Again, members, we're on House Bill 1614. Further discussion? Hearing none and seeing none, as the Chair Lady alluded to, there is a cost associated with House Bill 1614. So we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 1614 goes behind the budget. Brings us to item number 46 on our calendar. Item number 46 is House Bill 2322. You have a motion and a second. Chair Lady Hazelwood, you're recognized.
Thank you, Mr. Chairman. This bill would just require insurance companies to continue to pay for rehabilitation for those persons who have acquired brain injuries. That could be through a stroke, an accident, some other kind of medical emergency, where the doctors and the evaluating entities believe that additional time can make a tremendous amount of difference in the recovery level and quality of life moving forward.
All right. Thank you, Chair Lady. Members, we're on House Bill 2322. Further discussion? Hearing none and seeing none, there's a cost associated with House Bill 2322. So without objection, we will have to place it behind the budget and consider it at a later date. Without objection, so moved. That brings us to item number 47. Item number 47 on our calendar, also by Chair Lady Hazelwood, is House Bill 2323. You have a motion to second. You're recognized.
Thank you, Mr. Chairman. This bill just basically provides a ladder. Currently, you can be a misdemeanant and you can have multiple misdemeanors and never be punished at any more severe level. We had a horrid situation, a tragic situation in my community a year or so ago. There are other horror stories out there, but a young father who had 3 children under 4, the youngest child was just a couple of months old at the time this occurred. He was shot and killed on a public street in downtown Chattanooga by someone who had over 60 misdemeanor offenses. They should have been in jail at the current time. They had an outstanding warrant, but they were free. But they legally could carry a gun because they had never been convicted as a felon. This would change that, and it would just raise that. Change upon your 6th occurrence, then that would become a Class C felony. And if you continue to offend, then the level of felonies would continue to rise. It's just, I think if you, members of this committee, if you would talk to your district attorney, this is just a revolving door. You have these people in your communities too, I can assure you. We had someone in our community, we found that had over 100 felonies. They're still walking the streets. They check in and check out of the jail like you and I might check in and out of a hotel. So again, this is just an attempt to stop that, to put people who continually offend away. I will want to make clear that there is a provision in this bill. If you go for 10 years, if you straighten your act up and you're on the straight and narrow for 10 years, and then you get that sixth misdemeanor, and all of this is, it's permissive, it just gives the judge the opportunity to use this. It doesn't require it. But if you are, have a 10-year span, it's like a reset. So with that, Mr. Chairman, I stand ready for questions.
Okay, thank you, Chair Lady Hazelwood. Again, members, we're on House Bill 2323. You've heard the description. Any discussion? Leader Camper.
Thank you, Madam, Mr. Chairman, Madam Chair. Does this deal only with domestic assault, or is it any misdemeanor?
Chair Lady Hazelwood.
Are you targeting?
It's any misdemeanors, but there are, and thank you, Leader Camper, I should have mentioned this. The sixth misdemeanor, just any old misdemeanor, will get you up to the felony level. But there are some misdemeanors which, not being an attorney, I was appalled at some of the things that we have considered as misdemeanors. Those include assault against a first responder or a nurse, child abuse, child neglect or endangerment, domestic assault. All of those are misdemeanors. If you commit those misdemeanors and some others that are listed in the bill, then 3 times there.
Leader Camper.
Thank you.
Okay, further discussion. Again, we're on House Bill 2323. Hearing none and seeing none, there is a cost associated with House Bill 2323, so we will have to place it behind the budget, consider it at a later date. So without objection, House Bill 2323 goes behind the budget. Brings us to item number 48. Item number 48 on our calendars, House Bill 2325. You have a motion and a second.
Thank you, Mr. Chairman. This bill, we are working with the administration. It sets up an artificial intelligence advisory council. There are several similar bills that were floating out there that we've tried to bring into one, and we're still working with the administration on the composition of that council. So I would request that we roll this 1 week.
All right, you've heard the request that we roll House Bill 2325 by 1 week. Any objection? Hearing none and seeing none, House Bill 2325 rolled 1 week. That brings us to item number 49. Item number 49 on our calendars, House Bill 2426 by Representative Hicks of Washington. We have a motion to second.
Motion.
We have a motion to second. Looks like there's an amendment that has been filed by Vice Chairman Baum. 016259.
Motion to withdraw.
Motion to withdraw. Any objection to the withdrawal? Hearing none, seeing none, the amendment has been withdrawn. All right, that brings us back to the bill. You have a motion to second, sir. You're recognized on the bill.
Thank you, Mr. Chairman. House Bill 2426 makes changes to the County Powers Relief Act to further assist counties financially. The amendment states that the resolution or ordinance to impose a tax must be adopted by 2/3 vote of the entire county legislative body. The ordinance must have 2 consecutive meetings, and the ordinance must be identical at both meetings. In 67-4-2907, the amendment changes the qualifications for the tax to a 20% increase between the 2010 and 2020 census, or a 9% increase over the last 4-year period according to the special census. The county must conduct a special census at their own expense. After initial qualification, the county may use federal census estimates to maintain qualifications based on growth, and the comptroller must verify all the numbers. This amendment adds commercial property to the County Powers Relief Act. This bill updates the definition section and changes the definition of development to include residential and commercial property. Public buildings, nonprofits, mega sites, and other buildings remain exempt. Square footage is based on finished, heated, and cooled floor area. In 67-4-2908, the proposal is to increase the tax from $1 to $1.50 per square foot on new commercial and residential property. Counties can increase the rate of the tax after 4 years by a percentage of up to 10%, and they must adopt any increase by 2/3 vote on an ordinance following the same procedure outlined above. The tax is due upon the completion, but must be paid prior to getting your certificate of occupancy. If a county no longer qualifies under the County Parish Relief Act, they may use their private act, but only at the same rate at which it was previously set. So that's sort of the bill of its entirely and what it is intended to do. And I'll be happy to answer any questions.
All right. Representative Hicks, thank you very much for this description. Members, any discussion? Chairman Williams.
Thank you, Representative. I really appreciate your work on this matter. I know it's something that's it's a very difficult discussion. I have some concerns about it, some of which I've shared with you offline. I recognize that. I do have some concerns about the 20% cap. As you know, over a 10-year period, that'd be 2% a year. I don't really consider, based upon what we've seen in the state of Tennessee, exorbitant growth to be 2%. I feel like that percentage should be much higher. I do have a concern also with the idea of certain projects being exempted and whether they have a constitutional authority to be able to prohibit a tax or to allow for the deferment of tax for one individual or the other. For example, if I were to come to one of these 5 to 7 counties, depending upon the growth, if I came there and I built for a customer of mine a 500,000 square foot warehouse, and that warehouse, they were going to store tobacco in or whatever, dry it out if we had enough tobacco grown in Tennessee to do that. But if they were to do that, it was unheated, just really for shade and shelter. That would not apply. Your tax wouldn't apply.
Representative Hicks.
Thank you, Mr. Chairman. If it was not heating and cooled, it would not apply.
Okay. So under that premise, though, if 3 years down the road, a new employer came to town and I could make more money leasing that building to them if they added heating, cooling, fire suppression systems and offices and a distribution facility, would the local authority be able to go back and tax the difference between what they didn't collect before and what they did now, or is it just when it's built?
Chairman Hicks.
Thank you, Mr. Chairman. This is only when it's built. They could not go back.
So in essence, a member of my community or your community could say that they're just building shade and shelter, and then for the purposes of deferring this $500,000 or $500,000, $1 million tax, and then 6 months later, after a certificate of occupancy is received, they could technically modify it just to bypass the tax.
Chairman Hicks.
Thank you, Mr. Chairman. The good thing about this is all we're doing is setting this up for the county to basically be able to do this their way. Okay, this sets the parameters and this sets the growth patterns and the limits, but on any of this, it's totally up to the county. They can adopt this or they don't have to adopt this. They can set these limits at anything that they want to, okay? They just can't go over $1.50. If they want to put residential at $1.50 and commercial at 50 cents, then that's fine for them to do that in the way this is written. So it gives them the freedom to be able to do that. So basically, that's going to be a local decision, Chairman. That's what that's going to be.
Chairman Williams.
So, and I appreciate that. I don't know the current tax rate for any of these specifically because they're not my districts. But if you are currently taxing commercial property at 30 cents, you could raise that 300% based upon the passage of this law for all new construction and commercial. And if you didn't have one for residential, then obviously that percentage would be infinitesimal for those projects going forward. They're being built in these few counties.
Chairman Hicks.
Thank you. Yes.
Okay. Thank you.
All right. Chairman Moon.
Thank you, Mr. Chairman. And to the sponsor, a procedural question. You said it'd have to be approved by 2 votes, by two-thirds vote of the county legislative body, municipal body. Those are in regular meetings, so you couldn't have a meeting and approve it and then have 5 days later a special call meeting and approve it. Can you help me on that?
Chairman Hicks.
Thank you, Mr. Chairman. I don't think this necessarily addresses that in this part of the bill. It may, going back in the other part of the County Parish Relief Act that was originally stated. I would assume that it would be in two, not a special meeting. It would be more in the regular meeting.
Thank you, Mr. Chairman. Thank you, sponsor.
I think our legal has an answer to that. If you would like to go out of session to hear the response from legal, Mr. Joel Hayes. Any objection to going out of session? Seeing none, we're out of session. Mr. Joel Hayes.
Joel Hayes, Office of Legal Services, Chairman and sponsor. In section 4 of the legislation, it does say that the resolution or ordinance levying the tax must be adopted by a 2/3 vote of the entire membership of the county legislative body at 2 consecutive regularly scheduled meetings.
All right, any questions of legal while we're out of session? Hearing none, seeing none, we're back into session. Without objection, we're back in. And Representative Moon, any follow-ups there? All right, let's move on to Chairman Whitson.
Thank you, Mr. Chairman. And sponsor, again, I appreciate you taking time this morning to talk to me about our concerns we have with this applying to my county, Williamson County. And you had expressed that you're going to look at this will not apply to Williamson County by amendment later on. Is that?
Representative Hicks.
Thank you, Mr. Chairman. The intent of this legislation is not to do anything with Williamson or Wilson County whatsoever. This will only be an option for any county that is going over the 20% limit. And those counties currently are Rutherford, Sumter, Troutdale, Murray, and Montgomery counties. That's the counties that this would affect.
Chairman Whitson.
And again, thank you. And I appreciate you working with me this morning. The concern, though, is, the notwithstanding wording of the paragraph B that I think the intent is to add to this legislation. But I look forward to working with you before we get to full on this.
All right, thank you. Further discussion. Again, we're on House Bill 2426. Hearing none and seeing none. We're now voting on House Bill 2426, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 2426 moves on to full finance. All right, members, that is all the time we have today. All those bills that have not been taken up today will be rolled till next week's calendar. So anything else to come before the committee? Hearing none and seeing none, without objection, we stand adjourned.